And I would like to call the meeting of the Nurse Practitioner Advisory Committee meeting to order. My name is Samantha Gambles-Farr. I'm the chairperson, and I am happy to see everyone back this month. I will start by calling roll to set forth a quorum. First, we'll start with Dr. Edward Ray, co-chair. NP Sally Pham.
Present.
NP Jan Johnson Griffin.
Present.
Dr. Andrea Espinoza.
I think you're muted.
Thank you. Public member Betha Schnell. NP Dr. Kevin Maxwell.
Present.
Okay. And I'm going to say our public member Betha Schnell. Is she on the call, or is she attempting to come on, moderator?
I know she has prior obligations. She might be able to join us later.
Thank you, Dr. Maxwell. And with that being said, we have established quorum, with the only member who is not present is our public member, Betha Schnell. I would like to start on agenda item 2.0 with general instructions from our moderator. Thank you.
Good afternoon. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute your microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the committee. Such inquiries submitted using this feature will not be allowed. When asking a question, please make sure the question is directed at the host, me, in the dropdown. If any attendees utilize a profane name, they will not be called upon to prevent members of the public from being subject to profane language. While you are free to express criticism or negative views, for the sake of members of the public participating on the call, please do not use profane language when making public comments to the committee. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee members or senior staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief, friendly reminder.
Thank you, moderator. And now we will move on to agenda item 3.0, review and vote on whether to approve the previous meeting minutes. First agenda item is 3.1, which is review of the August 31st, 2021 minutes. I will start with members of the committee and call for any addendums or corrections for the minute meetings.
Chairperson, I did have one correction I wanted to offer for the August minutes. I believe it was on page 11 of the meeting materials. I was quoted as saying that there are 5 nurse practitioner programs. I think what I was trying to say, I don't think I was correctly quoted there, was that there are 5 recognized areas of certification that we were informed of. So I just wanted to clarify that in the minutes.
So noted. Any other corrections?
Yeah, there's one more on page 17. I think Kevin could probably see if that's correct or not, but I see that on page 17.
Espinoza, I'm sorry to interrupt you. That is from September We are
Oh,
currently
oh,
reviewing.
sorry, I
Yes.
thought we were looking at both. Sorry.
No, ma'am.
Every-
It's okay. I'm sorry to interrupt. Any other corrections? Okay, hearing none, let's move on. I would like to do 3.2 for the committee, and then we can open up to the public to go over both. I think that might be a little bit easier instead of stopping in between. So now, Dr. Espinoza, I know that you have one for agenda item 3.2 on page 17, correct?
Yes, I don't know. I think Kevin can help me with that, but I see that total of 6 hours. I'm presuming that's supposed to be years.
Yes. I would like it to be 6 hours. It is supposed to be years.
Yeah, and so it's also removing 2 hours. So
Yeah, I
it
think-
says years, right?
Anywhere that it references hours, I think should be changed to years as well.
Okay. Okay, any further corrections?
I would like to go, if I could just go back to the August meeting on page 9.
Sure.
It said nationals, no formal training in dermatology to sit for the boards. I just wanted to reference that board or clarified it as of the board that will be accepted by the OES, or a master or education that correlates to the national board, like a master prepared nurse practitioner in that specialty, sitting for a national board like the American Nurse Associations or the American Nurse Credentialing Center.
MP fam, are you speaking, which statement, whose individual statement are you speaking to? Yours?
It was, yes, mine.
Training correlates to what we get in our national certification.
Yes, yes. Thank you so much.
Did everybody get that correction? Okay. Okay. Any other corrections that anybody sees? Okay, hearing none, I would ask the moderator to open it up for public comment for corrections for agenda item 3.0, please.
For public comment now, I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Katrina Reyes would like to make a comment. 1 second, please. Go ahead, Ms. Reyes.
Hi, can you hear me?
Yes.
Oh, hi. Good afternoon. Katrina Reyes with the California Academy of Family Physicians. I'd like to just comment that the public comment that's reflected in both meeting minutes tend to be oversimplified, which then doesn't accurately represent the extent of the public comment. So maybe just for future meetings, if it's helpful, we can send in what we actually say during the public comment so that it be fully included in the minutes for upcoming meetings. Thank you.
You can always submit public comment in advance of the meeting as well as during the meeting.
And then just a note to the stakeholders on the call, all of our meetings are recorded and accessible for viewing at a later date, and that would have your full comments on each of those recordings.
Dr. Stephanie Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
Thank you for taking my comment. I had similar concerns regarding the meeting minute notes that reflected my comment as simply stated issues with not having standard of practice under the meeting minute notes of the 21st of September. That doesn't really reflect what I had stated. It really sort of, I think, does not do justice to the time that I, as a physician, have dedicated to preparing my comments, being present. It does not reflect the concerns that I have raised, and it further raises concerns about the processes and the integrity of this process.
Thank you, Dr. Dittmer. Committee Chair Gamble-Spar, there are no public requests, other public requests for public comment. Would you like me to close this window?
Yes, please. And thank you all for your feedback. We appreciate it. I did have one correction on August 31st. There seems to be the state of California, the state is left off on the draft up at the top. That's the only correction that I had for minute meetings. Okay. And with the stated corrections and acknowledgement of our public concerns, I would like to call for a vote. We'll start with the August 31st minute meetings for approval with said corrections previously stated. And we will just simply go down the aisle. Starting with myself, I vote in the affirmative. Dr. Ray.
Sorry for the interruption. This is Reza. Did we have a first and a second motion?
Yes, I'm sorry.
Move to approve the minutes as addended.
Thank you. May I have a second, please? Is that MP Fam?
Yes, yes.
Thank you. Thank you. Now we will conduct the vote. Thank you. I'll start with myself. Yay. Dr. Ray.
Yes.
MP Fam.
Yes.
Dr. Espinoza. Dr. Maxwell, NP.
Yes.
Thank you. And NP Griffin.
Yes.
And Public Member Schnell. Okay. The minutes have been.
Find out who made the motion. They did not
It was
mention
Dr.
who they
Ray.
were when they made the motion. Sorry.
Dr.
Thank you.
Ray.
Edward Ray.
Yeah.
Thank you.
Dr. Ray motioned and MP Pham seconded.
Perfect. I appreciate that.
You're welcome. Okay. The minutes will be adopted with said corrections for August 31st, 2021. Moving on, we will call for a motion for September 21st minute meetings with said corrections. May I have a motion, please?
I move that we approve the minutes from August 31st.
Dr. Espinoza, we're doing
Excuse me,
September
September 21st. Sorry.
with said amendments.
Yes.
Yes.
Okay, thank you. May I have a second, please?
Ann Griffin, second.
Thank you, MP Griffin. And now we will call for a vote. Myself, affirmative. Dr. Ray.
Yes.
MP Pham.
Yes.
NP Griffin. Dr. Espinoza.
Yes.
Dr. Maxwell, NP,
Yes.
and Betha Schnell, public member. And the minutes will be adopted with said corrections as voted upon. Thank you, guys. And now we are ready for agenda item 4.0, public comment that are not for items that are not addressed on the agenda. Moderator, would you give instructions for public comments for item 4.0, please?
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment."
Thank you, moderator. I would like to remind for agenda 4.0, this is specifically for items that are not on the agenda. If you have comments relating to agenda 5.0 or 6.0, we would request that you wait until we are discussing those particular agenda items. Thank you.
Committee Chair Gambles Farr, there are no public requests for comment. Would you like me to close this window?
Yes, please. Thank you. Moving right along, we are agenda 5.0, discussion and possible action regarding the procedures for the Impact Committee to provide recommendations or guidance on care when the board is considering disciplinary action against a nurse practitioner. We are thankful today to have someone giving us a presentation. Shawn Johnson, the Chief of the Enforcement Division on the Board of Registered Nursing discipline process, will be providing us with the presentation at this time. Thank you, Ms. Johnson, for being present, and thank you for the presentation you're about to provide for us.
Can you hear me?
Yes.
Great. Thank you. So I am Shawn Johnson. I'm the Enforcement Division Chief, and I'm going to be presenting an overview of enforcement for you today. I would love to answer any of your questions, and there will be an opportunity at the end of the presentation for all of your questions. Next. So today's objective is going to be an overview of the BRN's enforcement process. We're going to cover what triggers complaints and investigations, be expected during the disciplinary process, and then the types of disciplinary outcomes. Next. There are some common terms in enforcement. The respondent will always be the RN or the applicant. The complainant is the board's executive officer. The Office of the Attorney General prosecutes the board's cases, and the Deputy Attorney General is the attorney that are assigned to our cases, and they prosecute those cases. Our cases are heard by an administrative law judge, and they are in the Office of Administrative Hearings. There are statement of issues those are the pleadings that are filed on an applicant. We have an interim suspension order, which is ordered by an administrative law judge in the administrative courts. And a suspension that has been ordered by a criminal court judge is referred to as a PC-23. Next. Enforcement Division and investigations. We have some, these are our units within enforcement: complaint intake. We have intervention, cite and fine. We have our disciplinary unit and our probation unit. Intervention is not considered enforcement, but it is housed under the enforcement umbrella. And then investigations works closely with enforcement, but is not under the enforcement umbrella. Next. The board's mission is public protection, and pursuant to Business and Professions Code 2778, the protection of the public is the highest priority for the board. Next. So we're going to begin with complaint intake, and I'm going to take you through the process of a complaint as it flows through the enforcement process. And complaint intake is the first unit that it begins. Next. The caseload that comes into the complaint intake unit consists of licensees that are arrested and or convicted, public complaints of unprofessional conduct, incompetence, negligence, and gross negligence. We also receive applicants from our licensing unit that has either disclosed another disciplinary action against another healthcare license or has a criminal history. Even if the criminal activity is not disclosed, it may come up on the fingerprint record that is supplied to the board at time of application. Next. As you can imagine, we receive complaints from many different entities, such as patients, family members, employers, other state agencies, and law enforcement agencies. Next. When a complaint intake receives a complaint and there is an aspect of either substance abuse or mental health, the case will be referred to the intervention unit and they will be offered the intervention program. And that will happen as we simultaneously investigate and obtain records on that case. So I'm going to talk a little bit about our intervention program that we have at the board. Next. In 1984 and 1985, the California Nurse Association, BRN, and lawmakers collaborated and created the intervention program, which was previously called the diversion program. And in January 1st of 1985, the program was signed into law. This is a voluntary program and completely confidential. Next. In order to be eligible for the program, you must be a licensed RN in California without previous discipline or had been terminated from an intervention program for substance abuse or mental health issues. RNs that are not eligible, they have would have been previously disciplined by the BRN for substance abuse and or mental health. Or RNs previously terminated by our intervention program or any other intervention program by another regulatory agency. Next. There are two types of referrals into the program. The RN can self-refer themselves without having any complaint filed against them. And the board will send a letter of invitation into the program when a complaint has been filed and involves drugs, alcohol, or mental health. Next. There is an intervention evaluation committee that oversees the care plan for each participant in the program. It consists of 3 RNs, 1 physician, and 1 public member. And they all must have a background in chemical dependency and or mental illness. There's approximately 14 IECs across the state. They meet on a quarterly basis, and each IEC has about 15 to 30 participants assigned to each of them. Complaint intake also refers cases to investigations if needed. Next, we have 2 investigation units for our cases. There is the internal BRN investigative unit, which are non-sworn investigators, and they work mostly with practice and patient care complaints. There's also DCA's Division of Investigations, and they are sworn law enforcement. They work the more egregious cases that have either a patient harm or a criminal element to them. Some of the causes for an investigation are diverting of drugs from the employer, intoxication on the job, it could be arrest and convictions, or dishonesty, which would be theft, fraud, maybe pre-charting, attempting to cover up charting errors, falsifying medical records, or falsifying certifications such as advanced life support or the basic life support certifications. Some additional causes for an investigation are repeated medication errors, not advocating for the patient's safety, failure to follow infection control guidelines, providing medication to family, friends, coworkers, if there is patient abandonment, and also refusing to give handoff to the incoming nurse. Next. Once an investigation is complete, it's referred back to the complaint intake unit, where an analyst then reviews to determine the next steps. So we may close the case if there were no violations found. We send the case to an expert for review if the incident involved patient care and scope of practice. If there were findings that don't rise to the level of formal discipline, we may send that case to our citations unit. If findings were violations for formal discipline, we would then transmit the case to the Attorney General's office. And when there are criminal elements, DFI will sometimes refer those cases to the district attorney for prosecution. If the RN has entered the intervention program, we will put the case on hold once that investigation is complete. But if the RN completes the program successfully, we close the case. If they leave the program for any reason and do not complete it successfully, the board then continues on with the disciplinary process based on that investigation. Next. Okay, so we're going to move on to cite and fine. Next. So if a case doesn't rise to the level of formal discipline, the case will then be sent to our citation unit. This is an informal administrative action. And some examples of what we cite for would be first-time convictions, out-of-state disciplines, some very minor practice issues, fingerprint noncompliance, failure to update address of record, and then unlicensed practice. And there is an appeal process, both informally and formally, when a citation is issued. Next. There are exceptions to when the board can issue a citation. So if the violation is of the severity that revocation of the license or restriction on the license is necessary, this includes, but is not limited to, things like physical abuse, neglect, abandonment, fiduciary abuse, or deprivation of care or services. These types of cases will be transmitted to the Attorney General's office for formal discipline. Next. The citations are not published public record, but if requested, the board is obligated to provide these documents. And citations are purged 3 years from resolution of that citation. The license may not be renewed until that citation is paid in full. And we do send fine amounts to Franchise Tax Board for the unpaid citations. Next. So we'll now go over the discipline process, which is the formal administrative action against a license. So there are 2 emergency types of orders that we use in our discipline unit that the board can pursue. So if the licensee has been arrested, the board has the authority to appear before the criminal law judge and request conditions be placed on the license. The judge may then impose those conditions, or they can decline to order those conditions. If the judge places conditions on the license, it is immediately posted on the board's website and on NERCI's, and this order will be in effect through the criminal proceedings. And when those have concluded, that order is then lifted. Next. The other order is, so if the criminal judge doesn't order the PC-23 restriction, or if there has been no criminal hearings, we can pursue a suspension through the administrative court and request an interim suspension order from the administrative law judge. And they may order mandatory fluid testing, supervision, a type of remedial training. So we have that option as well through the administrative courts. Next. When it appears that practice may be impaired due to mental or physical illness, the board may order the RN to be examined, and this exam can be used as evidence in proceedings conducted if the RN is found to be unsafe. So the board may pursue disciplinary action, including revocation, suspension, or place that license on probation, or any other action deemed appropriate based on the disciplinary guidelines and the outcome of the exam. Next. Once the case is received from the complaint intake, it's prepared by the discipline unit and it's transmitted to the AG's office. Within a couple weeks, the case is assigned to a deputy attorney general. They prepare pleading or an order to compel, which is the 820 exam. And it could be either an accusation for a licensee. They prepare the statement of issues, which is what is prepared for an applicant. And for our probation unit, they prepare pleading that is called the petition to revoke. And those are the orders or the pleadings that they prepare for us. Next. If it's an accusation, the licensee has 15 days to file a notice of defense. And this is why the updating of your address of record is very important because of that time constraint. An applicant has 60 days to appeal the denial of their license once the statement of issues is filed. All of these documents state the cause for the action, or if a probationer, it states the violation of the probation condition in which was violated. All of these are published documents on both the BRN website and on the NERCY's website. Next. The respondent is permitted to present mitigating circumstances during settlement negotiations and at hearing. Respondent may choose to have legal representation in either of the situations, but it's not mandatory. Next. The possible outcomes of the case would be public reproval. This is the lowest form of formal discipline. This usually includes cost recovery for the investigation and prosecution cost of the case, and possibly courses for continuing education, depending on the reason for the disciplinary action. It could possibly be we usually have 3-year probation terms and apply conditions dependent on the reason for the disciplinary action. And these conditions are laid out in our disciplinary guidelines. There is the surrender of license. So if an RN surrenders their license, they will need to wait for 2 years to petition the board for reinstatement of the license, and 1 year if the surrender was for a mental or physical illness. There's the revocation of license, and a revocation can happen by default if the RN does not respond to the accusation that's filed by submitting a notice of defense. And we actually give about 25 days though for them to, based on USPS, I know it says 15 days, but we give them an extra 10 for mail. We want to make sure they get those in. And a revocation can also be ordered by the ALJ after a hearing has been held. An applicant could have a denial of license for either not appealing the denial of licensure or if ordered by an administrative law judge after hearing. And the board could possibly withdraw the pleading and no disciplinary action taken at all. Next. All settlements that are negotiated prior to hearing are called a stipulated agreement, or it's called a proposed decision if it's by an administrative law judge after hearing. And the order is pursuant to the recommended guidelines for disciplinary orders and conditions of probation. In the current guidelines, the uniform standards have not been incorporated yet. However, we do follow the uniform standards and are working on currently updating the disciplinary guidelines to incorporate the uniform standards in their entirety. Next. Okay, so we will move on to probation. Next. So the purpose of probationary terms is to first and foremost ensure public protection while we enforce all of the conditions in the decision and order. We try to ensure that the probationers have the tools to comply with the conditions and at the same time take any additional actions if there's either a violation of one of their conditions resulting in a petition to revoke, or if there's any other violation of the Nurse Practice Act resulting in an additional accusation needing to be filed. Next. Within our disciplinary guidelines, there are applicable conditions of probation. They're broken up into two groups. There are standard conditions of probation, which apply to all probationary cases. It includes conditions 1 through 13. The only time that all of these conditions don't apply is for applicant cases. There is no cost recovery ordered in our applicant cases. Next. The second set of conditions are optional conditions that may be applied if there is substance use or mental illness, and they include conditions 14 through 20, which include things like having a physical exam, a mental health exam, going to therapy, counseling, abstaining, and then, of course, drug screening through either urine, hair, nail. And so those are our optional conditions of probation. Next. As I mentioned before, non-compliance with any of the conditions of probation could result in further action against the license, including a cease practice. We do cease practice if we do get a positive drug or alcohol screening. They can surrender their license voluntarily through the probation program. A possible revocation of the license, and we do also do extensions of probation in order to allow them to either comply with a condition or if it was a low-level violation. Next. So I wanted to give you some statistical information so you can put the amount of disciplines into perspective a little bit more. Next. So as you can see, we have just over 450,000 active licensees in California. Of those, we only receive complaints on less than 2%. And of that 2%, we discipline less than 2%. So that just shows you really, and that discipline is a total of our formal discipline and our informal discipline for citations and the formal disciplinary proceedings. Less than 2%. Next. This slide is a little small. Hopefully you can see it, but I wanted to show you the number of advanced practice certificates that are disciplined. This is the previous fiscal year. And so you can see I have highlighted blue in the middle. Those are our nurse practitioners and our nurse practitioner furnishings. So out of those 800 plus cases that were disciplined, these are the amount of those that were a nurse practitioner with or without a furnishing. Okay, next. So that concludes the presentation. And if there are any questions, I'm willing to answer them now.
I'd like to ask a question if I could. This is Edward Ray.
Absolutely.
So we were provided with, I think, some helpful resources here in the meeting items that were sent out, and one of which was the recommended guidelines for disciplinary orders and conditions of probation, the document that's prepared by the Board of Registered Nursing, and I assume that this kind of informs most of what you're talking about. So it's notable that in this document, there are no use of the phrase standard of care or scope of practice and things like that, because I think until now, you know, the practice of nursing, whether it's as a nurse practitioner or another advanced practice provider, hasn't really been entirely independent. And so my question for you is, do you have an opinion about whether or not these sort of rules and regulations as written in the you know, by the BRN should be amended to more specifically deal with independent practitioners, since those kinds of questions may come up much more frequently?
We are currently in the process of updating those guidelines, and we will be taking all of the new laws and legislation into account when doing so.
Okay, thank you.
Any other questions?
Yeah, this is Kevin Maxwell. I have a question. What role would we have as the Nurse Practitioner Advisory Committee in these sorts of disciplinary actions. Is that a component of what we're going to be doing after we've dealt with AB 890?
I believe in previous discussion that was up to the committee to decide, I believe, at what level they wanted to have participation and then make those recommendations to the board. I'm not sure at this point where this committee would see themselves as being involved in the disciplinary process.
Point, Shannon. This is Lori. Thank you, guys. So the reason this is on the agenda is for the NPAC to make a decision to discuss this and to decide whether or not you want to adopt the disciplinary guidelines, whether or not you want to be involved in the updating of the disciplinary guidelines, and how the cases that involve a nurse practitioner that would have to go in front of our board would potentially be brought to you guys for input prior to it going to our board, so that we're in alignment with the statute that was created by passing AB 890. What the Nurse Midwife Advisory Committee did is they voted to adopt the disciplinary guidelines and to participate in the review of the disciplinary guidelines that specifically address the CNM practice. They also voted that any of the disciplinary cases that have to go in front of the board, that they request that the nurse midwife cases be brought in through closed session in the advisory committee first, and then their recommendation be passed on to the board. So that was kind of the discussion with the midwife committee. And my assumption is that this nurse practitioner advisory committee would probably want to do something similar to that. But we want to open it up to you guys for discussion now that you have a basic understanding of what our current process is, and it is inclusive of the APRNs, including we do discipline the nurse anesthetist, we do discipline the clinical nurse specialist, as well as the certified nurse midwives and the nurse practitioners, and have been doing those to all of those advanced practice registered nurses for many years. So Reza might want to jump in and kind of talk about some of the disciplinary process, how it works for the board, to give you guys a little more input on that too. Shannon is available to talk about that process as well, and really kind of the level that the board is involved and where you guys might fit.
So just kind of piggybacking off of what Lori said, the statute from AB 890, it's 2837.102 subdivision A, which says the committee, as in this committee, shall provide recommendations or guidance to the board when the board is considering disciplinary action against a nurse practitioner. And there was more or less similar language in the bill that related to nurse midwives, requiring the Nurse Midwifery Advisory Committee to likewise provide recommendations or guidance to the board on cases involving nurse midwives. So that's kind of where this is coming from. As Lori said, there's different ways to go about that. One is, of course, you could have cases brought into this committee for you to discuss in closed session and then provide a recommendation after a review of a specific case, and on an individual case-by-case basis, provide your recommendations that way. Another option is to, as Lori said, weigh in on the disciplinary guidelines that you saw. There was the link to in the meeting materials, and which, as you were told, are being updated and revised, and so you could incorporate recommendations into the revision of the disciplinary guidelines, so that rather than reviewing individual matters case by case and providing recommendations that way, you would provide guidelines that would be applied by the board and by administrative law judges when they are considering cases that involve nurse practitioners. Normally, without the mandate in the bills, AB 890 and SB 1237, these cases go directly to the board after an administrative law judge has reviewed the case and held a hearing and issued a proposed decision, or alternatively, it may go by way of stipulation. But in any event, it goes directly to the board. During a board meeting, the board has a closed session under authority under the Open Meeting Act, and the board members will have reviewed the proposed decision or whatever it is, a stipulation and any related materials, and they have a discussion in closed session about what the outcome of the case ought to be and whether they want to adopt the proposed decision or the stipulation or go in another direction. So again, a similar kind of thing could be done through the advisory committees in order to fulfill that requirement of the advisory committee providing recommendations or guidance to the board on nurse practitioner cases. Part of the challenge with that, with the route of reviewing individual cases on a case-by-case basis, is largely timing, and there's a couple aspects of that. One is your time. I don't know the volume of cases that you'd be asked to review, but it does take some time to review cases. And but another kind of just logistical piece of it is that we would have to schedule a meeting of the committee. You couldn't discuss these cases outside of a meeting. You could do it within a closed session within a meeting, but we would have to schedule a meeting, meaning a 10-day notice and convening a quorum and all that. And then you would have to discuss the case during that meeting, and then that recommendation that comes out of that would be transmitted to the board, which it would have to then consider and discuss. So logistically, and I should say, under the statutes that govern the disciplinary process and the hearings and the board's obligations, there are timelines. So for example, when the board receives a proposed decision from an administrative law judge, it has to take action on that decision within 100 days. It can decide to adopt the decision. It can make minor changes to it. There's several options, including it can reject the decision and obtain the administrative record and review that at a later time and decide what they want the outcome to be. But in the very first place, once they receive that proposed decision, they have to decide which of those actions they're going to take within 100 days. So that means they have to schedule a meeting within 100 days, and obviously there would need to be some time after receipt of the proposed decision. Once the decision is received by board staff, they send that out to the board members who review it, and typically they vote by way of an electronic mail vote. So they'll email back, and if they're in agreement on the outcome, then it just proceeds that way. If they want to hold the case for discussion, then it gets held, and those are the cases that end up being discussed in the closed session. So all that is just to say that once we receive a proposed decision, we're on kind of a timeline to submit it to the board members, have them review it, get back to board staff, and if necessary, have that case discussed in a closed session. So adding the step of the NPAC doing essentially all of that as well before the board itself reviews the case just creates kind of a logistical layer of complexity that if you want to go that way, we would just have to sort it out and figure out how to navigate. Go ahead, I'll stop there and open up for questions.
Can I make a comment? This is Ed Ray. I just want to make a quick comment. I was going to say, along those lines, I think maybe we should discuss as a committee about whether we would, if we're going to go that route, we just take on certain types of infractions or violations. In the disciplinary guidelines, there's a nice little categorization of different issues, everything from not renewing their license to, committing insurance fraud. There may be a certain subset of those types of cases that the group really feels should go through the committee, at least to inform the BRN. So I would just propose that to cut down on the sheer number of cases that we would have to involve ourselves with. I don't think most people here on the committee have much to say about somebody who didn't renew their license on time or something like that. Does that make sense?
I agree, Dr. Ray. I really agree with the narrowing. I would not want our committee to be a barrier to timing on due process for someone that's in the midst of this. And so I think that's something that's very important to keep in mind, as Reza had mentioned, the time constraints. I did want to clarify one point. So currently the midwives are involved in the revision of the disciplinary writings for the BRN currently. Is that correct? That's what they voted on? EO Melby.
Yeah, so I'll explain that process. The nurse midwife sections that are within the disciplinary guidelines, the disciplinary guidelines are a regulatory update.
Mhm.
So it does have to go through the regulatory process. And so as you guys are familiar, because you guys are involved in all matters that affect nurse practitioners, the nurse practitioner sections of that disciplinary guideline regulatory update would come through you guys for observation and comment. A similar process as with the nurse midwives. And
I
that's
would
already included in the statutory language.
I would be interested in perhaps participating in that if my other colleagues felt the same that are on the committee. Understanding that this is a process that the BRN has been doing for a very long time and has established a set manner for dealing with disciplinary actions. I have confidence in the system currently. So I open it up to the other colleagues on the committee for input at this time.
Yeah, I think it's something that, we probably all should have some part in, because we're fundamentally changing the way nurse practitioners are allowed to practice. So I think that's something that you definitely have to reevaluate disciplinary guidelines and procedures. And actually, if Janice Johnson is still on the call, I just had a quick question for her. So there's some terminology that's used in the disciplinary guidelines. One of which is practicing medicine without a license. And my question for you, and maybe Reza, if you can answer this, is, does that mean somebody practicing without a license, period? Or does that mean a nurse practitioner or other healthcare provider providing a type of care that they are not licensed to provide? And I'm just curious about that, because that seems like a very vague term. And, the BRN presumably has disciplined people before with these rules. And I just didn't know if you could provide some clarification on what that phrase means. Is Miss Johnson still on the call? Maybe she's left.
Shannon, are you still on the call?
I'm taking a look.
I just had to unmute myself. I apologize. I'm sorry, could you repeat that question?
Oh, sorry. So yeah, in the disciplinary guidelines, there is a specific category that is called practicing medicine without a license. And my question is, does that just refer to any practitioner practicing without a license, or is that specifically referring to nurses practicing, a type of medicine that's outside of their licensure? Because that helps me better understand how these guidelines are set up. It was a little unclear to me.
Yeah. So the practicing medicine without a license, that could be an RN that's practicing as an NP without the certification. That could be someone practicing who has maybe let their license lapse and have still been continuing to work under that license when it's not valid. So the unlicensed practice, there's a few different reasons why we use that.
This is Reza. To be a little just more specific, the piece in the disciplinary guidelines that you're referring to refers to a violation of Business Professions Code section 2761A2. Again, a 2761 subdivision A2. And what that says, it specifically, I'll read it for those who can't quickly pull it up. It says the board may take disciplinary action against a certified or licensed nurse or deny an application for a certificate or license for any of the following: unprofessional conduct, which includes but is not limited to the following. And then the particular subdivision is a conviction of practicing medicine without a license in violation of Chapter 5, commencing with Section 2000, in which event the record of conviction shall be conclusive evidence thereof. So it's specifically referring to a conviction of practicing medicine without a license in violation of Chapter 5. Chapter 5 is Chapter 5 of Division 2 of the Business and Professions Code. That is the Medical Board's Practice Act. So I think it is a violation of specifically, per se, practicing medicine, something that's governed by the Medical Practice Act without being licensed as a, appropriately as I think a physician and surgeon or whatever the appropriate licensure is under the Medical Board's Practice Act.
Okay, thank you. I appreciate that. That should be something that we may need to talk about, because there could be some gray areas where a 104 nurse practitioner might be in violation of that under certain interpretations.
And I have to say, the other reasons for unlicensed practice, like the lapsing of a license or working on a certification that you don't have, those for unlicensed practice, if they weren't an RN at one point, we do not have grounds to discipline them. So the only grounds for discipline on the unlicensed practice, if they had never been an RN, is through criminal prosecution with the district attorney's office. And then we do have the authority to cite them, the maximum citation amount for that as well.
Thank you.
This is Reza again. So just to kind of talk through how you might go about this. The disciplinary guidelines, there was a link to them in the meeting materials. I'm not sure that any of you necessarily would have any concrete recommendations today. If you do, we can certainly discuss it. But as you think about this, you can kind of come up with, for example, as Dr. Ray suggested, areas of certain particular categories of cases that you'd like to review on a case-by-case basis, or perhaps simply adding to the disciplinary guidelines to say, for example, just again, taking that example that Dr. Ray mentioned, a nurse practitioner who's in violation of Business Professions Code 2761A2 by practicing medicine without a license, ... You would provide guidelines that the board and an administrative law judge could consider in evaluating cases that involve that type of violation. So if you don't have any kind of concrete examples or thoughts today, that's something that you can reflect on and at a future meeting, present those ideas. And as Lori said, the disciplinary guidelines are incorporated into our laws by way of regulation. So in order to change them, that also has to go through the regulatory process, which, as you know, is a somewhat drawn out process. It involves, reviewing draft text and taking public comment and possibly updating the text and all of that, and then going through the whole administrative process to get it approved through several levels of review internally and then through the Office of Administrative Law before it's actually formally updated and made effective. But as that process is being carried out, Lori can correct me if I'm wrong. I don't know how far along we are in the update of those. I think we're at kind of a preliminary stage. So at this point, you can certainly come up with those types of ideas for things that would specifically relate to nurse practitioners. I don't believe currently that the current disciplinary guidelines, I don't think that there is any distinction or any specific section that deals specifically with NPs or sets any kind of unique guidelines or standards for cases that deal with NPs as opposed to all RNs generally.
Quick, Reza, and then give Shannon a chance as well. The disciplinary guidelines are just with our board right now. They have not gone to a phase where they would go to DCA for review or agency, and they're not anywhere close going to the Office of Administrative Law. So it is in very preliminary stages, and we can absolutely take input on that for both our Nurse Midwife Advisory Committee as well as our Nurse Practitioner Advisory Committee. Shannon, do you have any thing that you would share about our advanced practice nurses? You can talk about all four of them. Sometimes it's really good to kind of see the comparisons across practice for the nurse midwives, the nurse practitioners, the nurse anesthetist, as well as the clinical nurse specialist.
Yeah, well, one suggestion that I may have, if you're looking at maybe just being involved in certain types of cases, we may want to take, like, for instance, on the slide that I showed previously for the NPs and NP furnishings, there were, I want to say, 51 cases for last fiscal year. And if you took that, it's only showing you what the outcome was for those cases, but what it doesn't show you is what types of cases those were. So for instance, 40 of those cases may have been criminal convictions based on, possession of drugs or DUI or something along those lines. So if it's helpful for the committee, I could possibly take those records, those 51 records, and separate them out to show you maybe what types of cases we're receiving, and that may help you make a better decision on what types of cases you want to be involved in. And I would assume it would be primarily the practice issue cases.
Yes, I think that would be very helpful for us, Ms. Johnson. I would like that.
Okay, I can get that for you. Probably wouldn't.
Does anyone else think that that's a good idea?
I think I would, I think it would, in the best use of the time of the committee, if we were only involved, say, in cases that involve patient harm or harm to the public in the worst way, and otherwise, then the sole amount of time that we would be spending would be on looking at these cases that maybe wouldn't benefit from our input as providers in most cases. So I would sort of support drifting in that direction.
Thank you, Dr. Maxwell.
I would look at the guidelines and their specific categories, and maybe we can decide as a group or vote on which categories we should take on.
That sounds good. Dr. Espinoza, I see your hand up.
Yes, I would, and I agree with taking certain cases. However, what I would also like to see is participating in a revision of the guidelines specifically in those areas so that the guidelines themselves will bring out certain cases out to us. And then we can decide from there, or we can see what cases we can bring out. But I would like to participate in the specific guideline areas involving the 103, 104 nurse practitioners.
Thank you, Dr. Espinoza. Okay, so I think that we have made a decision, I believe, to how we would like to be involved moving forward, tentatively, given the fact that the disciplinary guidelines are in very much a preliminary stage, and then also in deciding which categories of cases that we would actually like to review to ensure that anybody who is going through this process has a timely answer, and that the BRN actually stays within the guidelines of what they have to meet as far as time is concerned. And And
And
so,
so are you making a motion, Samantha, to adopt the disciplinary guidelines and to participate in the revision of the disciplinary guidelines for nurse practitioners? Is that my understanding?
that was exactly what I was about to state at this time. Um,
Well, I'll
and
let you state it and then you can make that motion and get a second on it and I'll hush up.
okay, I am making a motion that we accept the disciplinary guidelines for the BRN at this time, with discussion for us to be involved as it relates to nurse practitioners, as well as evaluate and decide which categories of cases we would like to review in the future for disciplinary actions. May I have a second for that motion? Or okay, that was Dr. Maxwell. Any additional discussion before I call for a vote?
Do we want to take a little more time to read this? Because I'm guessing that most people haven't even read through the disciplinary guidelines. I did actually read through them. They're extremely vague as it applies to nurse practitioners. And I'm not sure that we should adopt it until we actually make the appropriate amendments.
Sorry, I'm gonna chime in. Currently, it is already adopted. So I just need to be very clear on that all cases right now with nurse practitioners do utilize the disciplinary guidelines. If there was a motion made today to not adopt this and to do something different, and we put that to the board and say the board decided not to adopt it, all nurse practitioner cases involved in discipline right now would halt. So I urge you not to do that. I would really hope that you guys would adopt the disciplinary guidelines and participate in the revision and be brought in as consultation on the nurse practitioner cases. And through that revision of the disciplinary guidelines, make the changes to the regulations for going forward to be able to handle those cases that will come into play after a year from now. So after January 1, 2023. So I just want you guys to be very clear on the fact that these disciplinary guidelines are in place. They are being used for nurse practitioners and they need to continue to be used going forward until changes.
Why do we need to vote on it if they're already being used? I guess I'm confused what this motion means.
So the specific part of this is to have what cases do you want to opine on as an advisory committee for the nurse practitioners? And that does need to be decided. And you guys did include in that motion for that part to be decided upon. The other thing is that you guys made in the motion to be involved in the updating of the disciplinary guidelines that affect the nurse practitioners so that you guys can have that disciplinary guideline input for, as Dr. Espinosa put it, the 103, 104 NP. So basically with it is the new scope of practice that came out through passing of 890 that we are now referring to them as 103 and 104 NPs. So so that's what that motion is for you guys to be involved in that, for you guys to write the new disciplinary guidelines that are specific to nurse practitioners, to go ahead and be involved in the cases that need nurse practitioner input.
But I guess what I'm asking is, why did you insert the part about adopting them? Because I understand the first two parts. We're going to participate in the revision and we're going to talk about which areas we want to deal with. But why are we talking about adopting them in the same motion? I don't understand that. You said they're already being used.
Go ahead, Brenda.
Speak to the motion that I put forth? So for me, the reason why I use the word adopting is for us to continue. Maybe that adopting is not the correct term, but to continue to adopt the current, what we're using, but then also to understand that, like you were stating before, the different sections of the disciplinary guidelines that perhaps need to be teased out once, we have 103 and 104 nurse practitioners. There are things that we would need to weigh in on specifically for them, such as, that statement, practicing outside of practicing medicine without a license, like you stated, that could present a problem for 103 or 104 nurse practitioners in the future. And so my rationalization of stating the motion the way that I did was to ensure that we would have some input and buy-in as it relates to the implications of AB 890 into the continued discipline of nurse practitioners in the state of California. Because
would you consider revising the motion to say that we would adopt this as a framework upon which we would like to make amendments and offer a subset of categories that the committee will weigh in on? Would that be fair?
I would consider that. However, it's already a structured frame. It's already a structured body of work that's currently being used. So I guess framework would be a good term, but I don't know if the things that I am concerned only because in completely restating my motion in a way that perhaps where we would try to deconstruct large portions of it. My primary purpose is to, of course, ensure the patient safety, but then also, as we're talking to the disciplinary actions, the only input that I feel is necessary from us relates to the 103 and 104 nurse practitioners. And so, I mean, does that make sense, Dr. Ray? Is what I'm saying.
I have concerns that you're putting RNs, nurse practitioners, pretty much everybody under the BRN under the same guidelines. And to me, it's like there should be carve-outs to specifically deal with situations that you're only going to have with 103s and 104s, or even just 104s. And so that's why, to me, it just doesn't make sense to have such a vague set of rules that we can't really, that we're already voting on without having really commented on it.
Well, the current NP practice is already regulated by these disciplinary guidelines already, currently. And so that's not going to change for people who are not seeking 103 or 104 transition to practice. And so the only thing that would need to change from my perspective from the impact committee is for us to speak to the disciplinary actions for 103 and 104 nurse practitioners. So I don't think that it's canvassing or throwing a wide blanket. This is a procedure and procedures that are carrying on today. I'm going to yield the floor to Dr. Espinoza so she can put her input in. Thank you, Dr. Espinoza.
Yes. So, and see if I'm understanding this correctly. The reason we're voting to decide to accept the current disciplinary action is if we don't, in a way, we're stopping the process. We stop ourselves from even being part of that process because those guidelines have already been out. But what it allows us by saying we accept them with the understanding that we will participate in the revision so that we put a stop. Otherwise, we will have no input whatsoever at that point, because if we're basically saying we do not want to be a participant in any of the guidelines that have been put out right now. And that may slow the process, is my understanding. But if we accept the current disciplinary action with the understanding that we are going to participate in those revisions related to 103, 104, and give guidelines as to what kind of cases we want to review or categories. And that's why we have to say we accept or not accept. If we don't accept, we're basically pulling ourselves out of the whole process. Is that my understanding? Is that why we need to vote on it?
I wouldn't say that we're pulling ourselves out of the process. It's just that we, as EO Melby previously stated, it means that we don't adopt or we don't agree with the current disciplinary guidelines of the BRN.
So that might stop things, is what, or at least we won't be participating in it in any way.
It would stop further disciplinary actions for the current NP's practice as in the current state that it is. Am I correct, EO Melby?
Perhaps I can respond. Unless...
Defer to Reza. He's been trying to kind of jump
Okay.
in, so I'm going to give him the floor.
Thank you.
Thank you. Really didn't want to talk over anybody and give everyone a chance to express themselves, but hopefully I can kind of clarify a little bit. I of course, I can't speak for Lori, but I can kind of speak to what I understand the request to be, and or the suggestion, and also that this is more or less what the nurse midwifery committee did. So a few things to kind of start off. First, as I said, the statute that's currently effective, 2837.102A, says the committee shall provide recommendations or guidance to the board when the board is considering disciplinary action against a nurse practitioner. So currently that's effective law. We're still at the stage of trying to sort out exactly how the NPAC is going to provide that guidance to the board. Until we kind of have that really ironed out, whether it's by revision of the guidelines or just sending all of the NP cases to the committee members before they go to the board, until we have that process ironed out, we're not really fully in compliance with that statute that says the committee needs to provide the guidance to the board. So when Lori says that those cases will stop, that's kind of the reason why, is that unless this committee has provided that guidance to the board, then we're not really in compliance with 2837.102. So I think that the ask to approve the current guidelines it is a temporary measure so that the board, and again, as you noticed, the current guidelines don't say anything specific to NPs, but it is, again, just a temporary measure so that we are in compliance, so that we at least have some guidelines in effect that would kind of fulfill that function. Again, not the way that we ultimately will want it to be, because I'm sure you'll all have input on matters that relate to NPs, but that's kind of the temporary measure, short of either halting NP cases or sending them all through this committee first. So that's the alternative. Is those are really the three options in order to kind of remain in compliance with that piece of the statute until the way that you really want to go about it is implemented. Again, the three options are approve the current disciplinary guidelines in the interim, or put a pause on NP cases, or send individual NP cases to you for review, and we would just have to probably operate on fairly short timelines to get your feedback and to relay that to the board. It might even involve scheduling more meetings where we'll have to ensure that we have a quorum so that you can discuss any of those cases as you know, you may decide once you see them. By the way, on the topic of halting those cases, as I said, there is timelines. Once we receive, for example, a proposed decision from an administrative law judge, the 100-day clock starts ticking. If the board doesn't act within that 100 days, the decision is presumed to be adopted by operation of law, and you know, the board and the committee essentially lose the opportunity to weigh in if we don't take action within those 100 days. And when I say we, I mean the board. I think the proposal about adopting the current guidelines, even though they really don't carve out anything relating to NPs, is kind of a temporary measure just to be technically somewhat in compliance with 2837.102 until the other piece is put into place, and that is your revision of the guidelines. As I said, as Lori said, that's in the very preliminary stage, and as I mentioned, it's a long way out before that's going to be updated and effective. For one thing, because you all will need time to review it and give, you know, your constructive input, and maybe you can do that in a meeting. Maybe it'll take multiple meetings, but it's going to take some time. And then getting through the regulatory process to have that actually implemented into law will take some time. Also, just a minor clarification, the statute that I've read a couple times is not necessarily specific just to 103 and 104s. It's that this committee is required to provide input on matters relating to any NPs. So it may be that you don't really feel a need to, distinguish NPs, ordinary, standardized procedure NPs from the guidelines that apply to RNs, or maybe you do. But you're not limited to just modifying the guidelines as they relate to 103 and 104 NPs. It's as to all NPs generally. And as Lori mentioned, just to clarify, the current disciplinary guidelines are effective. They're currently what is being implemented in cases, whether it's relating to an RN or an APRN. The piece that's kind of just missing right now is the NPAC providing guidance and input to the board on cases relating to NPs. So hopefully I've said enough and provided some clarification, but if you have any questions, I'm more than happy to try to provide further clarification. And that's not to say, again, that I'm not directing what you ought to do, but just wanted to help kind of clarify what I think Lori was suggesting and the route that the NMAC, the Midwifery Committee, went.
Thank you, Reza. Dr. Ray, do you have any further questions, or does anybody else have any further questions or input?
On really quick, I appreciate what Reza said. I think that clarifies it for me, since the Nursing Practice Act, I guess is what we're saying, is applying to, and we're talking about nurse practitioners in general, not just 103, 104. So I appreciate that. I withdraw my, alternative motion, but yeah, I want to continue to work on that, on those topics that we just talked about.
So what I would suggest is just if if you have specific recommendations here regarding the disciplinary guidelines, as I said, we can talk about them. Otherwise, I would suggest between now and the next meeting, make that one of your many focuses, and maybe at the next meeting we can talk about some specific, kind of more concrete ideas of how to update the disciplinary guidelines to fulfill that mandate.
Thank you, Reza. Shall I restate my motion, or does everybody have my initial motion?
Please restate it.
I move that we adopt the current disciplinary guidelines for the BRN as it relates to nurse practitioners, with the opportunity for us to give suggestions and weigh in on the disciplinary guidelines and regulatory statutes as it relates to nurse practitioners. In addition to that, we will await the information from Ms. Johnson for categories of cases for us to review to decide which cases we could potentially want to review as a committee as it relates to NP practice. May I have a second?
Oh, sorry. You could second it.
Sally
We already
Fair.
had a second. Did we
Oh,
not,
did I have a
Kevin?
second? Sorry, I'm sorry.
Yeah, I think Dr. Maxwell was on that one.
Yeah, Dr. Maxwell did it.
Okay, thank you. But just for clarification. Okay, we will go to a vote now. Is there any other discussion before we call a vote? Okay, hearing no discussion, I will call for the vote.
Before we go to the vote, that's just public comment.
Oh, yes, I'm sorry. We've been in discussion for a minute. I'm sorry. Moderator, please open us up for public comment. Thank you, Reza.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired. Then we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Dr. Stephanie Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
I actually raised my hand during this conversation because I was rather concerned that the public was not going to get an opportunity to weigh in on this topic. I would like to make note of the deficit that currently exists with the nurse practitioner disciplinary action that's been presented here. I think it is rather telling that the current state of affairs is that there's no clinical responsibility held by nurse practitioners under the Board of Nursing. That is not only just an omission in general that exists right now, but will continue to exist unless the actions that have been suggested by the current NPAC committee members is taken into account. The fact that the nurse practitioners currently, as they exist in our current healthcare system, practice with unclear and inconsistent supervision of physicians in the state, and medical malpractice is the standard to which they are held for their clinical judgment, falls on the physicians. This gap is rather alarming. It is rather alarming in the current state, and it is rather alarming going forward, especially since the very sort of brief introduction by Dr. Ray, as it is suggested, is that there is no current expectation for standard of care. The standard of care for medical diagnosis and treatment, as well as a professional standard relating to that care, should be the guiding factor for assessing disciplinary actions now and going forward. This is why the documentation, in my personal opinion, presented to the NPAC across all of these different committee meetings has consistently fallen across a line of conflict of interest. The only support for practicing without standardized procedures, i.e. the practice of medicine, has come from nursing, none of which has come from physicians. Thank you very much for your time, and I hope that we maintain patient safety in the center as we go forward.
Thank you, Dr. Dittmer. Scott would like to make a comment. 1 second, please. Go ahead, Scott.
I guess. This is a minor question. In the last slide that was presented with the disciplinary action for nurse practitioners, the one that with the very small print, there was the number of nurse practitioners who had had certain types of disciplinary action taken. And I was comparing that to the total in the previous slide. So there's like 500,000 RNs. Of those, I looked at one, like 200 of them had had their licenses revoked. On the next slide, for nurse practitioners, it was 8 nurse practitioners had their licenses revoked, but it doesn't tell us how many total nurse practitioners that's out of. So we're missing a denominator. Can someone clear that up for me?
Thank you, Scott. Dr. Cynthia Yovano.
One second, really
Sorry.
quick.
Go ahead.
Shannon, are you on, and do you have that denominator that you can quickly hand over?
I do not have that right off the cuff. I would have to look that up, but it is a number that we definitely have.
Okay, just to guide the public then, Department of Consumer Affairs has a data portal on their website that you can actually access, that has all of the annual licensing statistics for every single board and bureau underneath them. So if you go to dca.ca.gov/data/index.shtml, that will take you to the data portal. You can then access licensing statistics. Based on that licensing statistics, you can choose active license, renewed license, new license, license applications. So you can go into active licensing, and then you can choose the fiscal year, the DCA entity, which is our Board of Registered Nursing. All of the other boards and bureaus are under there. And you could choose the licensing type of nurse practitioner certification. The nurse practitioner certification right now shows that active license for fiscal year 1920 is 27,640.
Thank you. Dr. Cynthia Yovanov would like to make a comment. 1 second, please. Go ahead, Dr. Yovanov.
Hi, can you hear me?
Yes.
Oh, perfect. Thank you for taking my comment. I'm actually quite concerned with the conversations that have been going on. Part of it is, you know, in the bill, as council has stated, is that this committee is a committee of recommendations, not a committee of discipline actions. And so it is a huge concern with the conversation that this NPAC is trying to move forward in regards to disciplining nurse practitioners and having that power. It is obvious that the scope of knowledge varies in regards to the population that the nurse practitioners function in. And it is obvious historically and today, hearing the conversation, that this NPAC is very biased. And I have huge concerns that if this current board were to have any oversight of disciplinary actions, that it will be perceived as discriminatory as to any nurse practitioner in practice, whether they are a nurse practitioner in 103 or a nurse practitioner in 104. I actually am requesting that the NPAC board considers an entirely different committee, a committee of disciplinary power that have a mixed NP practice of the population foci to our national certification that is familiar with our practice, that will work in concert with the BRN. So I am very concerned with these conversations and having this current board, this current NPAC, have any kind of oversight to nurse practitioner practice, no matter what field we are practicing on. So I strongly feel this is a biased NPAC, and that any measures brought on by this NPAC can be perceived as retaliatory to any nurse practitioner practicing in California. Thank you.
Council Reza, I'm just going to take just a moment and respond to that. I'm going to go ahead and read the statute again. This is the statute implemented by the legislature, not by the BRN. Business Professions Code 2837.102, Subdivision A. The board shall establish a nurse practitioner advisory committee to advise and make recommendations to the board on all matters relating to nurse practitioners, including but not limited to education, appropriate standard of care, and other matters specified by the board. The committee shall provide recommendations or guidance to the board when the board is considering disciplinary action against a nurse practitioner. That's what the law says. The law says that this committee, the Nurse Practitioner Advisory Committee, shall provide recommendations or guidance to the board when the board is considering disciplinary action against a nurse practitioner. So there is no other committee that the board is going to form to be a disciplinary board or something like that. The legislature has spoken. This is what they've said. I've read that statute now. I think it's fairly clear. I don't know what gives you the impression that this committee is retaliatory against NPs or biased. So far, this committee hasn't reviewed cases or, in my opinion, expressed anything that would evidence any kind of bias or retaliation, or I don't know where that's coming from. But ultimately, the simple fact is the statute says that this committee needs to do this, and that's what we're trying to abide by. So there you go.
Thank you, Reza. Margaret Parsons would like to make a comment. 1 second, please. Go ahead, Margaret Parsons.
Question with the consideration of disciplinary actions. And I think the comments reviewing the concern of medical practice what the structure is and what the 103 and 104 nursing practice will look like as we go to an independent practice, and what scope and what standards we have really need to be thought about, and that there will need to be additional language, I would believe, for this expanded practice to make sure that we protect the patients and keep patient safety in place. So I think a lot of thought and consideration of putting forward these next very important steps and the consideration and the clarification of the details of what does this expanded practice look like and where are the limits of that expanded practice, and things that are put in place to protect patients and make sure that we don't have some sad and unnecessary events. So I appreciate the committee's continued work to really put in the thought and details for patient safety. Thank you.
Thank you, Margaret Parsons. Committee Chair Gamble-Spar, we have a we allow one comment per section, and somebody would like to comment again. Would we like to let them comment again, or should we hold the two? That's it. This is the last one. Or she said that there was others ahead of her and she would wait it.
So there are no other commenters after this person who wants to make a second comment. I will leave that. Reza, is that okay for us to do that? That's okay, right?
In your discretion.
Okay, I will allow it, moderator. Thank you.
Thank you. Dr. Stephanie Dittmer would like to make another comment. 1 second, please. Go ahead, Dr. Dittmer.
On my second comment here. It is specifically around the current guidelines and the legislative body that has been passed. It appears to me that we're supposed to be making recommendations at the NPAC level for these for the disciplinary actions. However, it is still unclear to me by what's been described why everything would come to a regulatory halt when these are recommendations being given to the board. And you're not necessarily going to be implemented depending on what happens with the board and whatever legal activities come thereafter. I wanted to make sure I think my interpretation is sound, but I think that's both a comment and a question.
Thank you, Dr. Dittmer.
This is Reza again. I'm not sure I understand what the comment is. Perhaps I can explain and hopefully answer that, but if not, it's because I don't quite fully understand. I've read the statute. It says that this committee must provide guidance to the board on disciplinary matters involving nurse practitioners. That's what we are trying to fulfill. If this committee doesn't provide any guidance to the board on matters relating to nurse practitioners, then we won't be in compliance with that part of the statute. So whether it's by way of written disciplinary guidelines or an individual case-by-case review, one way or another, this committee is supposed to provide some kind of input to the board on cases involving nurse practitioners. So that's what we are trying to get in compliance with, so that we're not in violation. If we're not in compliance with that, then the only other way to remain compliant is to not move forward with cases against NPs. So hopefully that clears it up, but that's, I think.
Reza, I think she's just making the point that if they're already using these guidelines, why do we need to vote on it now? You know, if they're already disciplining nurse practitioners using the existing guidelines. But I think it's a moot point. I think we're just in the spirit of, you know, doing our job. We're adopting these guidelines, or at least we're moving to adopt these guidelines so we can get our jobs done and make those changes as needed.
Thank you. Very good. Okay.
Dr. Ray. Hearing public comment, thank you for your public comments. And I would now like to call for a vote for the motions that are on the floor, starting with Dr. Ray.
Yes.
MP Sally Pham. MP Jan Griffin.
Yes.
Dr. Espinoza. Dr. Kevin Maxwell, NP,
Yes.
and Public Member Betha Schnell. Okay, we have met our quorum and the motion has passed. Okay, we are now ready for agenda item 6.0, discussion and possible action regarding the draft regulatory language pertaining to the implementation of Assembly Bill 890. And we will start. I will just start with opening the conversation that the information was sent in the additional supplemental information that was sent out on Friday. There was an original draft that was sent out on the October 26 meeting, and those have thus been amended. E.O. Melby, would you like to have the opportunity to speak to the adjustments or the amendments, or you or Reza, would you guys like the floor to discuss?
I will
you.
start off and then I'll actually hand it off. Real quick before we move on, Samantha, we did not get your vote on the motion. My assumption is
Oh.
it was a yes. Is that
Yes.
correct?
Yes,
Thank
thank you.
And so just to be clear, we do have Heather Hoganson. She is the DCA regulatory attorney who drafted this regulation with us up and in the panelist, and she is here to speak on regulatory language for the implementation of AB 890. On our website, we did include in the meeting materials the draft regulations. You will see in the agenda item summary, there is background, there is a summary of changes specific to each one of the regulatory sections, 1480, 81, 82.3, 82.4, 85.3, 85.4, and 87. And then directly below the agenda item summary, you'll actually see the proposed text. Any text that is underlined is new text added through working with the three subcommittees. The subcommittee assigned to section 0.101, 0.103, and 0.104. And so those are on there. If you see text with an strike through, that means that it was either removed or moved. And if there's text with no underline or no strike through, that is current regulatory text that has already been passed and is currently implemented as is. And so the one additional thing is I want to point out the blue text. So as you guys are aware, the initial draft language was put on the website for beginning review on the 22nd of October in advance of the interested parties meeting that was held on the 26th of October. So now just a week short of a month ago. There was that interested parties meeting. So based on the information from the interested parties meeting, our DCA regulatory attorney, myself, the subcommittees, and board's legal counsel, Reza, met with individual subcommittees, and based on the feedback that they received in that interested parties committee, they had some further recommendations, and you will see those edits in blue text. That blue text is the updated regulatory language after the October 26th interested parties meeting. Today, when you guys review this, and I will open this up to Heather Hoganson immediately after this, I will be writing down and making note of the issues or discussions around this or recommendations, and this will be brought forward to our board tomorrow for them to start a regulatory package if they choose to do so. So that would mean that effective tomorrow or Thursday, when our board is able to access this agenda item and they're able to take this into consideration, our board may choose to start the regulatory package based on this language. Thus, at that point, our board's regulatory team will write an initial statement of reasons, an executive summary, a final statement of reasons. They will put supporting evidence-based documentation within that. And then that would then be cleared and moved through them from the BRN to Department of Consumer Affairs. Department of Consumer Affairs would review it. They would provide input, seek clarification, and then if everything is kosher at that point, it would then move to agency. Agency would then have a review session. They would ask for clarification and any updates at that point as well. And if everything goes well, that would go then to the Office of Administrative Law. And then once it is with the Office of Administrative Law, that is when it would go out for a 45-day posting period for public comments. So all of the stuff that we've done preemptively to this point was not a requirement. It was in the spirit of getting input, the spirit of receiving all of this wonderful communication back and forth from stakeholders so that we can get a baseline, so that in the hopes of when it went out to public comment at the 45-day period, once it's with the Office of Administrative Law, that we would not have a lot of revisions to do. Each time that we have a revision, once it gets to that section, it goes back out for a 15-day posting period, and that can be stuck in a loop for quite a long time. And the goal for our board is to have this regulations done so that we can have it ready for the January 1, 2023 implementation date. So just some process kind of overview right there, letting you know that we have not even come to the public comment period where the Office of Administrative Law accepts it and we go out for a 45-day comment. And so there's much, much more to come after this, but this is where we're going to garner your input and your recommendations, in addition to what was already done as these were created. And I will pass those on to the board tomorrow. And then the board will make a decision whether they'll accept this, revise this, defer any action, deny it, whatever happens. We're not sure. I can't speak for the board, but that is what will happen tomorrow. But I will bring forward any comments from you all today, so that you are absolutely represented tomorrow with our board. And then Heather, our DCA regulatory attorney is on, and I would love to give her the floor.
Thanks very much. As EO Melby mentioned, there has been, in terms of regulations in general, there has been a great deal of outreach for this project before the formal process even begins. So I commend you on taking all of these comments that we've had on the public outreach meetings and the subcommittee meetings. We started with kind of a skeleton of a regulation to comply with AB 890, and we've been fleshing it out. And I know that there's a lot of comments, letters that have come in and that are in your materials that have some additional comments for you to consider and decide whether or not some of those things need to be added as this skeleton is fully fleshed out. But as EO Melby mentioned, this is the beginning of the process still. You may see this in come back a couple of different times as different comments are received, as agency or the director makes comments. But if you had any comments on the draft or in response to the comments, I am ready to take those into an account as we process this forward to go to the board tomorrow.
Dr. Espinoza, you're muted.
Thank you. One of our subcommittees, Loretta did a great job in presenting or giving us a vision of what she sees this the 103, 104 and transition of practice would look like in terms of requirements and training. And I wanted to ask her if she wouldn't mind repeating that for the public and for other members of the committee, because you did such a good job.
Well, thank you. I will try hard to do that again. And if you notice that I missed something, please hold me accountable for that and redirect or ask clarification. it's been a very long day for us at the Board of Registered Nursing. We did have an NMAC committee meeting this morning, and PAC meeting now, and tomorrow we'll go into a 2-day board meeting. So please bear with us. And so currently, with the passing of AB 890, a nurse practitioner who graduates from school will can become licensed in California through 3 different ways. The first way is they've graduated from a California board approved nurse practitioner school. The second way is they've received national certification and graduated from a program that is not California board approved. The third way is through an equivalency. Based on whatever way they went, they end up with a certificate that lays on top of their RN license. And so that with that nurse practitioner certificate, they can hold out as a nurse practitioner. Within our regulations, we do have categories of nurse practitioners that they can hold out as. And within those categories of nurse practitioners, they can be a women's health nurse practitioner. They can be a women's health / gender related, nurse practitioner, a psychiatric mental health nurse practitioner across the lifespan, a pediatric nurse practitioner with primary care or acute care focus, a neonatal nurse practitioner, an adult gerontology primary care or acute care nurse practitioner, and then family individual across the lifespan. So that nurse practitioner who receives that certification within California, and we're talking about brand new grad, will work 3 years as a nurse practitioner is known today. That is under standardized procedures and with the collaboration of a physician with oversight through those standardized procedures. Another process that's in their standardized procedure is that they must be part of a licensed healthcare facility. And so at this point and going forward, any new graduate nurse practitioner will have 3 years operating under the guidance of a physician with the use of standardized procedures. Then after they complete those 3 years, if the nurse practitioner chooses to, they can do the transition to practice. They can submit the proof of 4,600 or hours or 3 years full-time equivalent experience through this attestation through an application to our board. And if they choose to do that, they would be considered to be changed from just the normal new grad nurse practitioner, the one that we're all currently familiar with, to a 103 NP. That 103 NP, and again, I'm going to clarify that I'm using the terms 103 NP because that follows under the 103 section within the new statute, and 104 NP, I'll use that, but that is not our final names. We're still asking for public input on those final names so as not to provide very clear naming convention for the public. But for the standards of this right now, the 103 NP would then work without standardized procedures, but within a healthcare facility that has other healthcare providers. An example they gave Dr. Espinosa would be like they would work within Kaiser. And they would do that for an additional 3 years. So they have 3 years as a nurse practitioner under physician guidance with standardized procedures. And now they'll go into another 3-year period working within a healthcare facility without standardized procedures with the ability to collaborate with other healthcare providers. And that would go for an additional 3 years. At the end of that 3 years, people can stay as a 103, or they can choose at that point to do another attestation that they've completed this training, this mentorship, this collaboration, whatever that it ends up being called within our regulations. And based on that, they can submit that application to our board. We would review that, and we would then change their standing to a 104 NP. As the 104 NP, and that is after 6 years post-graduation, that nurse practitioner can then work independently in their own clinic if they choose to, within the training and education that they've had for their national certification. And so that is where we stand right now. I know when we get to the section 104, there's discussion on decreasing that second 3-year time period within the healthcare facility related to the Doctorate of Nursing Practice education that they received clinically. And so that is incorporated in regulation, and that could shorten that second 3-year time period. The other part that is within the regulatory language here is the grandfathering in, and those are for the nurse practitioners who are not a new grad. Those nurse practitioners that have already worked under the guidance of a physician with standardized procedures, because that is the only way that nurse practitioners have been able to operate in California, can get that 3 years counted if they come in within the last 5 years, so that it shows recency. And so with that, they would not have to repeat that additional 3 years because they've already completed that 3 years. They would still have to complete the transition of practice if OPES decides that there's an examination that needs to be completed. And then at that point, they would go into that second 3-year time period to do the training, mentoring, observation, however someone wants to include that, but that work within that healthcare organization with other members of the healthcare profession and not in their own independent clinic at that point. And then once they complete that 3 years, then they can go on and apply for a 104 NP so that they can do that and work independently within their national certification. So hopefully that is as clear as I explained it before, Dr. Espinosa. And if I missed anything, please let me know, and I would be happy to provide additional clarification.
Thank you, EO Melby.
Comments?
Yes, we will. Well, actually, EO Melby, did Ms. Hogan have any additional?
Yeah, I'm sure there's more that Heather would like to speak to as we talk about the regulatory language.
And pretty much I would like to get your input as a committee as to any concerns or requests you might have on this language, and then we can just have a kind of a back and forth if you have specific questions on things.
Okay, thank you. Dr. Ray, the floor is yours.
Yeah, I just want to say this is the first opportunity we've had as a committee to really discuss, the draft language, given the scheduling and other issues. So appreciate that opportunity. What in regards to what EO Melby just mentioned about the sort of grandfathering portion of the regulatory language, I just want to express my concern that having basically grandfathering in clinical experience from within 5 years of transition to practice. The only issue that I see with that is that it doesn't necessarily incorporate mentorship with the idea of somebody who is going to transition to practice if they're practicing in a more traditional role as a nurse practitioner. So I just want to throw that out there, that just that language, in my opinion, might be better tweaked a little bit to reflect that they have to fulfill all the same requirements if they are going to use that previous experience toward their their minimum number of hours. There were just 2 other quick things I wanted to mention, and a lot of this comes from the interested parties discussions that we had. I found that very informative, and so some of the ideas that I gleaned from that were good points. Number one, there's really nothing in the regulatory language, at least the draft that I've seen, that deals with the statute's mandate that there be some specifics about under what conditions referrals are made by 103 or 104 nurse practitioners to physicians, what sort of written agreements need to be in place. I didn't see, unless I'm missing something, I read through it, I did not see any specifics at all about that. And I just have concerns that that's going to create a lot of ambiguity once these regulations are put into place. And then the second point I wanted to make was, somebody brought up a very interesting point. I don't know how many people here are familiar with the California prohibition on the corporate practice of medicine. This is something that affects physicians. Corporations are not allowed to employ physicians. because they do not want those corporations to influence the practice of medicine. The language is very specific. It says physician, it doesn't say anything about nurse practitioners. This opens up the floodgates that you could get some unscrupulous, corporations moving into the state of California to employ a bunch of nurse practitioners to perform duties, under their guidance, because they're immune to this statute. And I realize that this is a law. This is nothing that this committee or even the BRN can do anything about. But I think it would make sense to, because the spirit of the law covers anybody practicing medicine, that there be some language in the regulation to address that concern. That, in other words, reinterpret that, or at least raise this to the appropriate level to have people address these concerns, because it would be very hypocritical to basically allow the corporate practice of medicine, just because somebody doesn't have an MD after their name, that they're not held to the same standards as physicians. So those are just two areas that I wanted to throw out there that are missing from our regulatory language.
This is real quick on that, if I may, Dr. Ray. So on the latter point about corporate practice, maybe you already are well aware of this, but 2837.104 subdivision G talks about corporations and other artificial legal entities shall have no professional rights, privileges, or powers. I presume that was kind of intended to get at this prohibition on corporate practice of, of NP practice here. Are you suggesting that we need more than that, or does that kind of?
I mean, I'm not a lawyer, I'm not a legislator, but to me, that doesn't really address the question at hand, because it doesn't say specifically that, it would be a violation of either statute or regulations for a corporation to employ a nurse practitioner with the specific idea of, basically running their practice. Because currently for physicians, there are specific prohibitions on that.
Schnell, member of the public. I just wanted to actually second what Dr. Ray has stated. In fact, in my write-up that I submitted on my section 104, I did include an extra section that stated that I was concerned with lack of clarity about when and how referrals happened, as well as the lack of clarity of what the supervisory relationship how it's defined during the proctoring period. I think both of those are extremely important consumer safety issues that are not well addressed in regulations. I agree with Dr. Ray on that.
Is there something specific that you would like the regulations to clarify? I'm happy to create something here, but I need to know what you would like it to do.
Yeah, I mean, I wasn't on either of those committees. I was on the Transition to Practice Committee, but I do think it's worth, even if we adopt all these other components of the draft regulations, that we at least carve out a section that perhaps more specifically, after a period of debate, discusses or addresses the concerns about how those agreements are going to be set up between, for example, a 104 nurse practitioner and referring physicians, under what conditions those agreements are made. I think there should be some language about that, because I know if I were a nurse practitioner who was a 104, I'd be very concerned that I wasn't in compliance if I didn't follow some specific guidelines. And right now there are no guidelines. The statute is extremely vague about it. So I think the regulation needs to fill in the gaps. I'm not an expert in that area, but maybe that might be something that a subcommittee could work on, and we could come back to the committee and bring that language. As far as the corporate side of it, like I said, I'm not a legal expert, but this is something that in medicine circles we talk about all the time. There's very specific rules about who can employ a physician and what standards they have to follow. And my understanding of the current statutes on the books are that really doesn't specifically apply to nurse practitioners, because until now, we've never had independent practice practitioners outside of the medical field. So I'm just anticipating that this could be a concern. I know that regulation isn't necessarily going to deal with, the legal side of it, but, perhaps there's a way in the regulation until those laws are passed that they can specifically say that, you know, the board should consider that the same standard should be held for any healthcare practitioner who is independently practicing.
Questions really quick, and I have some questions for you, Dr. Ray, and some questions for Heather as well, and then just some additional comments and such. So Heather, is there a different health and safety code or anything out there that has the clarification of referrals and such within that? Maybe a health and safety code or something to that, because my understanding is that as a 104 NP, when they have their independent practice, they do receive approval through CMS to bill. They're under DHHS as well, and they work within those avenues. And so I want to make sure, as we're talking about these, that we stay within what the BRN typically has jurisdiction of, and that we don't start to overstep and interfere with any of the other statutory requirements that the other healthcare agencies in the state have. And so I just had a question to you on that. And then a question to Dr. Ray is, when you guys, as physicians, work, maybe open up a outpatient surgery center or something to that effect, and you have to have, in order to license that surgery center, a referral process in place as part of the policy and procedures, where you have a referring hospital and that you have privileges at that hospital to be able to accept the patients if something were to go awry at that standalone outpatient surgery center. Is that stuff outlined from your board, or is it outlined from accrediting agency like Quad AFS or some other similar entity like that? So that could help give us some guidance on where we want to look for that type of oversight.
You know, it's interesting. There's a lot of different departments and areas that kind of dabble in this area. You know, the way that a physician sets up a corporation to incorporate their own practice has very specific rules. Your relationship with the hospital has specific rules that are under completely different statutes. And, you know, any sort of ambulatory surgical facility that you're using has an entirely different set of rules that they have to follow. And I think it's a combination of all the above. I'll be totally honest, I've never had to set up an independent clinic in the state of California. I did so in another state. And, you know, the rules and regulations were a little more straightforward in the state of North Carolina than they are in California. So I'm not an expert in that area, but I do know that, you know, there are very specific pathways with which the physician is held to account in terms of, you know, their medical decision making. They cannot be basically mandated by a corporation to practice medicine in a particular way. And, you know, I just want to make sure that any sort of interpretation of the statute kind of holds the same spirit for all healthcare practitioners, because I can't imagine that they would want to hold different people to different standards if our ultimate interest is protecting patients.
Agree. Thank you. Heather, did you have any input on that?
I would have to look up some of the specific things as to other healthcare practitioners. I vaguely do recall that there were some requirements.
There's a Stark law. The Stark law. STARK. So we fall under the Stark law.
Right. So I would have to see if we want to mirror some of that, or in terms of referrals, I believe not the nurse midwives, but non-nurse midwives have in either their statute or regulations something that said that if they're going to have a referral agreement that they must have, it needs to be within someone who's within 50 miles or something like that. So then the question to this committee becomes, you know, do you want to make any specific requirements on the referral agreements that are listed in 103 sub F? It says it has to be a referral agreement. But if we want to have,
real quick, Heather, that Stark law is under CMS. And so again, that's why we need to be very careful that we as a board do not overstep into other state agencies and their laws, right? So with that being with CMS for the physician self-referral law, my understanding is that would then carry over and there would be something within CMS, which is what any nurse practitioner who wants to bill has to have CMS approval. And you cannot have independent practice without being able to bill. So at that point, I believe that that would fall under CMS and not under our board. And so that's really where a lot of education needs to take place, where a lot of people think that our board has ultimate jurisdiction over every single aspect of nurse practitioner or even RN care, and we don't. And so like a common thing that we get at an RN level is staffing ratios. They think that our board has the ability to affect staffing ratios, and we don't. That falls under CDPH. We strictly focus on the education and preparation, the licensing of, and the disciplinary actions of. So those are the three main focuses of our board, which is education, preparation, licensing, and scope of practice, and discipline. So with that, when we start to get into these other realms, when we're talking about setting up agreements and billing and any of those things, that falls outside of our jurisdiction. And so I understand that we want to address those things, but I think that we need to do a lot more research on that to make sure that we do not have any overlaps or conflicting. Because if we make a recommendation here that goes into regulation, it won't make it through the Office of Administrative Law. It'll be kicked back because they will specifically tell us that this conflicts with this health and safety code or with something else.
But one thing we could add would be we could specify in the regulation kind of a reminder that a patient has the right to receive a copy of the referral agreement. That is definitely something we could put, something like that in there. That's not conflicting with another law. It's kind of more of a reminder, but I wasn't sure if you wanted to do something on that line.
Dr. Espinoza, I see your hand up.
Thank you. On the referral stuff, certainly that brings up a lot of issues on whether there's kickbacks and Stark laws violations. But my question is, why, if it's not very specific as to what that referral requirement is. Certainly for us, we are expected to have a referral bank, but we're not required to write down or have a relationship. I just think that if a nurse practitioner is going to be practicing independently, you don't want to encourage people taking advantage of the nurse practitioner by saying, okay, I'll do this if you give me all your blah, blah, blahs. We don't want to encourage those kinds of things. So to me, I would leave it as open as it is for physicians. And just having it on your documentation that's the way you're going to do. That is your referral system. If I need help with blah, 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 I will refer them to this panel. I will refer to this panel. And without establishing any relationship, does it say I don't think it says specifically we have to establish a specific one-to-one relationship. That relationship can be the relationship you establish as an independent practitioner. And this way it avoids putting the nurse practitioner in a position that can be very be taken advantage of.
I agree, Dr. Espinoza. One of the things, so first of all, as it relates to Stark's Law, nurse practitioners we do practice under Stark's Law currently. So we are held to that standard currently in our current practice. So that's not anything that's changing at this point. Second of all, as it relates to the referral system, so within 2837.104, I think it states that the nurse practitioner shall consult and collaborate with other healing arts based on the clinical condition of the patient. And so physician consultation shall be obtained and specified in individual protocols. So, in setting up independent practices and businesses, you set up business plans and you set forth those relationships. But like you said, when you start, that doesn't really separate them as an independent. If you're dependent on someone and you have to set up this written in paper relationship, that honestly that physician colleagues are not held to in most circumstances, unless I'm wrong. And so I think
I'll jump in here real quick, Samantha.
Yes.
When you are establishing a clinic or outpatient surgery center, or I'm trying to think of anything outside of a healthcare like collaboration like Kaiser or something, but you're out on your own. In order to get through the licensing process, you have to have CMS approval. And then once you receive CMS approval, then you apply out to the various insurance companies that you want to get reimbursed with. But you can't do that until you get CMS approval. And then when you go to the insurance companies, they check that you have CMS approval, and then they will kind of barter an agreement. Some say I'll pay 80% of our contracted price, or I'll pay 70% of our contracted price, et cetera. And within that process, you also go through a health and safety code clearance. You go through a city clearance where they check, just for like fire alarms and how you store your gases, such as oxygen, et cetera, within your facility. And there's a bunch of training and such that goes on with, waste and removal and everything at your clinic. And those are set up in your individual protocols. And so that does have to be written down. Those individual protocols need to be established in your policies and procedures. And they are kept at your clinic or facility, and are able to be pulled by any kind of reviewer that may come in if they have a complaint or something. Again, that is established through the individual clinic and not through a board of medicine and not through the board of registered nursing.
Right.
So
I guess
that's why you
perhaps
have
I
the
didn't say that right,
individual
but that was my point
protocols.
exactly, was that these are things that most business owners
And here.
Samantha, I'm not sure if you can hear us, but we have lost connection with you. You do have an alert up on your screen that says you have a low bandwidth, poor connection. So you may choose to turn your camera off and attempt to rejoin audio at that point. We will wait for you. Dr. Espinosa, as we're waiting for Samantha to rejoin, did you have any further comments or communications around that?
No, I just, I think you're right. We have to set up our policies and procedures in our office. I just wanted to comment, we don't have our policies to make referrals as needed, blah, 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 but we don't have any set up a specific doctor or specialist that is a cardiologist, for example, that we say, I'm going to make the referrals. We can't do that. And if we do have something like that, for whatever reason, because there's an agreement that there's no financial relationship that's being gained there, other than a relationship of making referrals, because they happen to be in the same building as you.
Yeah, and it would also be based on the patient's insurance and who their network is. So
Exactly.
You have to take that in consideration as well. So Samantha, glad you're back. You had some poor bandwidth and we lost you for a moment. We were just kind of talking while you came back. So we'll open it back up to you.
No, I was stating exactly what you were saying before. It seems, sorry, my internet seems to be on a delay right now, but everything that you stated, and with Dr. Espinosa, and I think that goes into the spirit of what Dr. Ray is also speaking to, of course. And so I think that would already be taken care of as far as moving forward with referrals. I don't know if you guys can still hear me. Dr. Ray, I'm sorry.
I think one other comment I want to make along the lines of what Lori was saying. I was more specifically speaking to the section of statute 2837-104 that was dealing with a plan, a referral plan that it mandates, be drawn up ahead of time. And I realize that creates some logistical issues that you guys just raised. But I more or less was wondering out loud if the statute, the regulation should include any language about, specifics of having this plan in place before, a 104 nurse practitioner is allowed to practice or something along those lines. Can I just raise one more question?
Yes, please.
Hopefully this is an easy one. You guys, Lori, I think you said last time that there was like a naming contest for the 103, 104 nurse practitioners, so we don't have to keep calling them that. Did we come up with any ideas of what people want to refer to? Because that's something else we might want to put in regulations so that there's less ambiguity, especially among the public. Because if I tell somebody, I'm a nurse practitioner 103, nobody knows what that means, but maybe something more specific.
That is correct. We have asked for some input from our public. We haven't received a lot. We are hoping to receive more, and we will ultimately change calling anybody a 103 NP to something much more clear and less ambiguous, as well as the 104 NP. When we get that language in, I will share it out to the committee. We'll have you guys vote on it. I think absolutely it would be something that you guys should vote on. And then what will happen is it doesn't necessarily have to be in regulation. We can refer back to the statute still, because that's obviously what our law is regulation based on statute. So we can do that. But what we can do once we get names that you guys like and vote on, and we do that in our Breeze system, which is our licensing system, there will be modifiers added to the nurse practitioner certification on their license lookup. And it will state that they are able to operate as this type, which would be 103, but the new name for that, or this type, which would be a 104, or in the new name for that. And so that will come on our public license lookup. And so when you go into verify the license and you type in a person's name, it'll pop up the Breeze public view, and it will say, for an example, it'll say Loretta Melby, that I am licensed since this point, I'm clear, and I'm licensed as a nurse practitioner in the specialty of psychiatric mental health, and I have been cleared to work as whatever that naming convention is, a 103. And so that way the public knows I have that more independent practice than I originally had. And my employer would know that as well. So we're just not there yet, but that does not necessarily need to be in regulation. What we would do when we get that naming convention is say, this is the name for this statute, this NP that meets the statutory requirements and such. But we haven't got any real good ones yet. Sorry. I wish we did. It'd be fantastic to have that at this moment.
Dr. Ray, as it relates to your previous statement about the nurse practitioner for 104 having that relation in place, I think that would be a difficult task, only because you would have to apply and go through those steps of becoming a 104 NP before you could ever really establish those things into place. I think that would be a difficult task to do. I think that's something that would have to come after the transition.
In that case, maybe just set a time period, like within whatever 90 days of establishing themselves as a practice or something. I don't know. I'm just putting it out there because I think that could be a concern, especially in disciplinary issues, if they ever arise where inappropriate referrals or referrals were not made. You just have to have some specifics.
I agree.
Is Shannon Johnson still in our attendees list? She can actually, if she's in the attendees list, I could have her elevated up to speak, because I'm sure that there's NPs that have not referred appropriately as it is now, and she can kind of speak about that. But I'm not actually seeing her in the attendees list at this moment, which is totally okay. She did her presentation and would not need to speak on that. But what we could offline is go ahead and get a response from Shannon and share it out to you, Dr. Ray, so that you're able to kind of see how that's handled currently as well. That might be of benefit.
That would be great.
Dr. Espinoza.
So can I bring up something different? Are we same topic? Are we still on Dr. Reyes's comments, or can I go on to something else?
Please, I think that Dr. Ray, have you finished your statements?
I'm done.
Okay, thank you. Dr. Espinoza, the floor is yours.
Okay, thank you. I wanted to go back to transition to practice. I know that it was agreed that there would be grandfathering in. And I think it may, looking at the reading that section, and I'll read, it says, transition to practice means additional clinical experience and mentorship provided to prepare nurse practitioner to practice independently. The transition to practice includes and is not limited to managing a patient panel, working in a complex healthcare center, interpersonal communication, blah, 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 blah. The board shall, by regulation, define standards for transition to practice. Clinical experience may include experience obtained before January 1st, if it meets the requirements established by the board. Now, we haven't established yet what type of clinical experience would grandfather somebody in to that the transition to practice. My opinion is that at the very least, there should be a transition of practice for a year for any a nurse practitioner who has been practicing clinically in the last 5 years, which was, so anyway. And one of the things that I brought up and I keep bringing up is a mentorship. And I think and we haven't really talked about too much about the mentorship, other than it's hard to understand or hard to implement. But it seems to me in the transition to practice, whether it is with the experienced nurse practitioner or the new graduate who was coming into 3 years, that at the very least, a year of transition to practice would be important for a nurse practitioner who has been experienced. Or we need to define why they aren't doing that. What defines the transition of practice, which I don't think we have had yet. And with that, they talk about mentorship. Mentorship to me is creating clinical competencies and to see this is what you need. Certainly I related to when I was in residency. And as a resident, I'm already a doctor. I'm in my field of specialty, but it's established you cannot practice independently. In fact, you can't. So what they do is a mentorship committee set up, and we're actually given a mentor to practice, who is going to be the person who follows me in the next 3 to 4 years. And with that is a committee that is a clinical competency committee. It's not a disciplinary committee. It is a competency where they have already set up, or somebody says set up, what those competencies have to be before you can be independent. And if I'm not meeting, we have little things we fill out once we do so many C-sections or whatever. When those are, when I complete that, that goes to committee, okay, they complete. But if there's something I'm missing, my mentor will come down, listen, Andre, you need to do blah, blah, blah to meet your milestones. Otherwise, you can't practice independently. So that's done. So competency, however those set up, there are competency committees. In fact, I pulled up, and a lot of organizations, particularly large organizations like FQACs, like university settings, big clinic settings. I don't know if Kaiser does, maybe Jan can tell me, have set up certain committees that say have competencies. Now it's maybe different for in the public sector, but certainly in the settings that we're defining right now, that a transition to practice must be completed and the 103 must completed. I think it allows to have these kind of mentorship competency committees, and and we talked about that part of it, that even could be where the attestation at mentor at test. Now, I think Reza has brought up that we can't talk about mentorship or competency committees in 103 or for 103, but certainly it states in the regulation or in the law that we should have that mentorship. And I don't think that we have that. And there is something that was put in there. I think that it was put in there specifically to help that transition. Now, if we believe that a nurse practitioner has been practicing many years, has developed that, then let's define it so that we can say, yes, you have transitioned to practice because you have met that, and therefore you can at least remove some of that time. It says that to me, it's quite clear that the transition to practice is a requirement. Without defining that specifically for the nurse practitioner who's going to be grandfathered in, I think that people will be concerned about that, and it's not fair to the nurse practitioners as well, and for the most, and especially for the people that we're serving, if we're not being very specific, giving guidelines to what that transition of practice is.
I hear you on that, Dr. Espinosa. I do have a question and a comment and a question for you. And so just for some basic education that goes out to our stakeholders and stuff that are on the call, every nurse's practice, whether it's an RN, NP, nurse midwife, nurse anesthetist, clinical nurse specialist, public health nurse, anything that falls underneath the Board of Registered Nursing for the state of California, their practice is completely dictated on competency. They have ability to have a very broad scope of practice, but they are only able to do any of that once they've been deemed competent. And that occurs through many different modalities. And that is after they have been completed their education studies and have been licensed in California. And so that competency is typically done through a healthcare agency that they are working with. And so if they're hired at a clinic,
I can't hear.
Nursing practice. Additionally, if they are employed through a large healthcare organization or a hospital, as part of their onboarding process, they would have their competencies completed. And then hospitals, a lot of times, will re-up those competencies on a WebEx or sorry, I just got a note that said WebEx just died. Are you guys all still able to hear?
Yes.
We're still here.
Okay, great, good. And so with that, some of the hospitals would, as part of their orientation or onboarding, establish competency. And additionally, with the privileging at a hospital or in an organization, they would then be required to have those competencies, and those competencies are kept in that provider's employment file. And if there's ever a complaint, if there's ever an investigation, if there's ever any kind of review that is done, they pull that employee file, and within that employee files, their competencies are reviewed. So are you thinking something different and over above those competencies that are done through the employer, and you want to establish a competency through the board? Or what are you kind of envisioning with that, Dr. Espinosa?
Sure, I'm envisioning it at wherever we're going to accept a transition to practice attestation, for example. The working independently, my assumption is here that this was put in because this is a new nurse practitioner. This is not the previous nurse practitioner. So that's why the transition to practice was put into the law. And it says additional clinical experience and mentorship. We haven't defined that. Now, if we ignore it and say, oh, well, it means what it meant in what the nurse the competency that done in the job setting or in the work setting or school setting or the education setting, and they meet that competency. If that's what we're going to accept, and that's going to be what they call additional, because a mentorship is different. A mentorship is not working with anybody. It is very independent, and there is something that we gain. I would say the majority of physicians do not feel well practicing independently till after probably practicing 3 years after their specialty. Most physicians will go on to practice in a big group setting for at least 3 years. Because of that mentorship relationship that you develop, that collaboration. So what I'm saying is, I trust that the nurse practitioner training has competency, established competency. But this here is saying means additional clinical experience and mentorship. Then let's define it for our or even at the sake of the people that we're serving. Because it's clear here to say we've already done it, then why did we even put that in there? Why didn't we talk about a 103, 104, and let's just skip it? And it certainly doesn't talk about the new graduates in here. It doesn't use the word new graduates in any place. So I feel, and when we talk to Reza, it can't be put into a 103. So what I envision is that everybody goes through that wherever facility somebody's going to do transition or practice, that they will have some type of mentorship committee there as the law is asking for. And with the idea of this is where they're going to go. This is what we need to set up so they'll be able to do that, even if it means a committee. I think that people will be happy. Any organization should be happy to be able to provide that for their nurse practitioners, because it would allow the physicians to be able to do other things independently of supervising the nurses. So I at least propose at least 1 year of anybody's doing the transition to practice for the nurses have been practicing in the last 5 years.
Can I make a comment?
Well, no, let me finish. And then I think I'm finished. I'm okay. I lost my thought right there.
I think,
Sally, after you make a comment, I do want to give Heather and Reza time to chime in and answer on what they would recommend us to do regulation wise.
So had her hand up for
Yes,
a while now. So
thank you.
oh, Jan, you could go, because I didn't have my, how do we put our hand up?
she literally put her hand up.
She has her hand up.
Oh. Okay, she could go.
I lost you all for a little while. So at one point, Dr. Espinoza asked, I felt like she asked me to explain what happens at Kaiser. Several years ago at Kaiser in the Central Valley, we established a program that we called the Nurse Practitioner Excellence Program, where a new nurse practitioner coming into Kaiser received two mentors. One was an NP and one was an MD, and they worked closely with those two with the support of the Nurse Practitioner Excellence Committee, meeting monthly and reviewing their progress as they went along. They eventually graduated. I don't remember the specific time frames, but it varied depending upon what the individual needed and what the department they were in. The program was so successful in the Central Valley that I understand, now please remember I retired about a year ago from Kaiser, that program is being rolled out across all of Northern California. So I think that's probably what's happening at Kaiser. And I hope that answers Dr. Espinoza's question. Thank you for the opportunity to talk.
Thank you.
Yes, so you know, when we talk about grandfather, we're not what I'm thinking is we're not grandfathering new grads in at all. So new grads are following the pathway that is set up in our legislations and suggestions. I think a lot of NPs are currently practicing. We're thinking about grandfathering in. They've been practicing, you know, like if you talk about Kaiser, many of them are practicing 20 plus years, right? So it's really they have experience and a lot of time too in clinics they are really experienced, and there's really not even there's physician supervisions on paper, but not necessarily you know the what you're talking about in terms of like the mentorship, because they've been practicing already. So I think there, I don't, I guess I'm a little bit confused as, you know, in terms of thinking, you know, new grad could be grandfather in, and that is not the case at all.
No.
I think also to speak to something that was mentioned before when we had this discussion is, you know, I think that it's a wonderful thing to have, of course, mentorship for anyone. But trying to mandate that within organizations is something that I think is just difficult to do, and really outside of our scope of power as it relates to mandating that someone have a mentorship within the program or within different organizations. I just don't think that that's going to be something that's applicable at this point. I do think that I agree with MP Pham as it relates to the grandfathering clause within the 5 years of date. Within the transition of practice has clearly stated, or what has been written that we voted on was 46 hours or 3 hours equivalent time. As it relates to that, you have to be within your specialty. So no one who would be outside of their specialty applying for the 103 would even meet criteria to be able to transition at that point. They would have had to have been practicing within that subsection of specialty. As it relates to the mentorship, I think that if there's more conversation that needs to be had about that, I'm of course open to that. But I think that mentorship is very difficult to really nail down. I think to really put a caveat or a pin in it for this particular instance, at least in my opinion. But
Thank
I'm
you, Samantha. I do want to interject here and let you guys know that we have about 15 minutes left
Yeah.
of this meeting. We do
Yes.
still need to make a motion, get a second on that motion, get
Public
public comment, get a vote, or if you guys are not going to make a motion and this is just information sharing, that could be done as well, and we can go right out to public comment. And then we do have an additional agenda item, which is voting on the calendar for next year. That may need to be taken to an additional meeting, except the problem is that there's no additional meeting scheduled at this point. So we're kind of in a catch-22. I do love the conversation that we're having, and I wish that it can go on for a lot longer, as I think that we're learning a lot through this process. I do want to give it to Heather real quick to make sure that she has any of the input that is needed from you guys in response to maybe updating regulations, so that we can accurately present your input to our board tomorrow. I believe Heather is on the board meeting with me tomorrow, and we'll be going over this discussion with myself and our legal counsel, Reza, tomorrow with our board members. So we want to make sure that we capture everything. So I'm going to open it up to Heather, and then we do need to go out to public comment. And I want to make sure that we're mindful of the next 15 minutes of this meeting.
Thank you, EO Melby.
For those of you that were looking at the drafts that we had at our October 26th outreach meeting, I know you all were listening to that meeting, even though you weren't panelists for Open Meeting Act reasons. But we did add in the 1482.3, the requirements for certification as a 103, to subdivision A4A. We did add the transition to practice included the clinical practice experience and mentorship. So we did add that mentorship in there, and that the clinical practice experience is already defined in the board's regulations at 1480 sub M as supervised direct patient care in the clinical setting that provides for the acquisition and application of advanced practice nursing knowledge, skills, and competencies. So that part is in there right now. If there is something that you wanted to further define as mentorship, I'm happy to put that in. But there has been discussions, as Chair MP Farr says, mentorship is really hard to mandate, to quantify, and we wanted to be careful that we didn't introduce any potential bias by mentors in as they perform their mentorship duties, but also in regards to the practice settings having separate rules, regulations, internal policies, sort of things that might impact how they would attest to that experience.
Dr. Espinoza.
Then I think we need to say we are not following transition to practice, and in the way, and we're not adding mentorship. That's what. So, can I make a motion or not yet? So if we're not, oh, I'm sorry. Can I make a motion?
Yes.
Or should
This is Reza.
Reza.
If I may,
Reza.
real quickly, you can make a motion, but I just wanted to, again, kind of remind you what's going to happen going forwards. The board itself is meeting tomorrow, as you know. They're going to be presented with some draft regulatory language, and as Lori said, any feedback that you'd like her to convey. If you're able to come up with some concrete proposals and language specifically that we could take to the board tomorrow, that's something that they could consider. Otherwise, any kind of additional changes you want to make, if it's not really concrete today, then it's not really going to get presented to the board tomorrow, which means it would have to go before the board at a future meeting. And as we've tried to kind of keep a reasonable pace on this, not to rush the process, but there's a lot of pressure on the board from a variety of external factors to implement some regulations so that this law can be implemented by January of 2023. And as you've been told, the regulatory process, even assuming we get our text approved tomorrow, is going to take some time, and that's what we're shooting for, is January 2023. So as of right now, you're certainly welcome to make a motion. If there's revisions, I would ask that they be concrete so that it can be presented to the board and discussed with some specificity rather than just raising concerns and areas of ambiguity, but without any kind of specific proposal to address that. Otherwise, this process could kind of go on and on and on.
Okay.
So that's not to, again, I hate to kind of, my intent is not to rush the process. It's to explore all the issues and address them as best we can, but also kind of stick to a certain timeline. So some of the comments and issues that have been brought up so far, perfectly valid and great concerns and things to continue to think about. And as we've said before, this is not a one and done kind of process. We're working on a regulatory package here that hopefully we'll have in place by January 2023. But nevertheless, you can continue to raise issues and come up with proposals to address them. And we can continue to kind of flesh this out well into the future. So, if you're talking about being more specific about what mentorship looks like or what the referrals to physicians look like, those issues, I by no means discount those as concerns, but I don't know that we are kind of ready here today with a concrete proposal to address some of those things. So if you're making a motion, the hope is that by the end of the board meeting tomorrow and Thursday, that there's something that's reasonably fleshed out enough that the board can approve so that we can then start the regulatory process. And then, we can continue to talk about some of the other issues that may not have been addressed. But also, I just want to kind of highlight a couple of things that were added in blue in the regulatory text relating to transition to practice under the proposed section 1482.3. As Heather mentioned, we added the phrase mentorship just so it mirrors the language from 2837.101. We specified that the hours used towards the transition to practice must be completed after certification as an NP. So we're not talking about we're not going to allow inclusion of hours that one obtained in school, for example. There was an addition as well that the hours must be completed in direct patient care. So hours that are not in direct patient care are not going to count towards the transition to practice. Also, in subdivision A3 capital B in blue text there was added a requirement, or it was spelled out more clearly, that the person signing the attestation form on behalf of the applicant who wants to become a 103 NP, that person signing the attestation must specialize in the same area or category of nurse practitioner certification. So that even though we're not fully fleshing out what the mentorship looks like, at least there's the requirement that a person attests that the NP has performed those hours, and also that they specialize in the same area so that they're qualified to provide that supervision and make that attestation. Sorry, I'm just looking at the text. So I'll leave it there. To get back to your question, Dr. Espinosa, you can certainly make a motion, and unless anyone else has any comments they want to make before we do that.
Dr. Espinosa.
I think also there's one other area related to the attestation form. Can that be brought up? Jan and I had talked about that during our subcommittee. Can that be brought up?
So,
And
oh,
I think that what Reza has said is that's the sort what we've talked about, which is having attestation forms for transition to practice 103 and 104. Those are the sort of fine tuning things that can be done at a later date. The important thing is to have the attestation form there now. And then if we have to fine tune it, we can do that. So thank you for the segue in bringing that up, but I think we can wait on that.
Okay.
That's just my opinion.
Okay, so I still would like to make a motion, if that's okay.
yes, please move forward.
Okay, I make a motion that the transition to practice, that everyone, all nurse practitioners do transition to practice, but 2 years may be grandfathered in for people who have 5 years experience.
May I have a second on that motion?
Sorry, can I make sure I understand the motion? Do you mind restating it, please?
Yes, and that all nurse practitioners do transition to practice, but may remove 2 years for nurse practitioners who have 5 or more years of experience.
So I think Reza, so Dr. Espinoza, what you're saying is that you are making a motion for people who are experienced nurse practitioners.
Yes.
They not be grandfathered in, but that they have 2 years removed from the 46 hours or the 3-year full-time equivalent requirement, requiring them to have 1 year of transition to practice in order to meet the requirements.
Yes.
So you want to change the subsection for the transition of practice as written.
Yes.
Sorry, this is Heather Hoganson. Just so I can understand, you dropped out a little bit for a second there. 2 years out of the 5 years still would have meant they've got 3 years in. So I think I missed an important piece there.
Yeah, so they would do at least 1 year of transition to practice before they move on to 103.
Okay. Reza, do you need to say anything or no?
I'm just processing it. I'm sorry. I'm looking at the statutory text in 2837.101C, which says, and this is the piece that we all refer to as grandfathering, at least as I understand your use of that term. The statute says clinical experience may include experience obtained before January 1, 2021, if the experience meets the requirements established by the board. So that to me is grandfathering, and it's basically allowing the NPs who have had many years of experience before AB 890 was a thing to use that experience towards the transition to practice. And I understand now what the motion is. I don't know if I'm splitting hairs or if this is an allowable imposition that we can make. Again, the statute says if the experience meets the requirements established by the board. This seems to be kind of a specific requirement, not a general requirement relating to transition to practice, but a specific requirement about grandfathering. And I'm trying to decipher whether the statute was giving us kind of leeway to really impose limitations on the grandfathering, or whether it just gave us leeway to specify criteria for transition to practice and anyone who had experience prior to January 2021 that met those general requirements relating to transition to practice ought to have those hours count.
Can I say something, Reza?
Sure.
So with the proposed motion that's on the floor, of course, we're always seeking to do patient safety, but we are also hoping to increase access to care. And by putting this in place for nurse practitioners who are already working, who already have experience prior to 2021, as stated in statute, that they would not be eligible once this bill, hopefully once we meet our timeline with 2023, that they would not be eligible to even start until 2024, because they would have to do 1 year of transition to practice in addition to the years that they've already done, even the time that they're serving now as we work towards defining these, as we work towards this regulatory process. So I am definitely not in favor of creating another barrier to access to patient care for providers who are currently already working with multiple years of experience.
And so I understand, but I'm coming from the side that the transition to practice is a very specific clinical experience, different from anything they've had before reading the law. And I think that's why it was put in. So to me, having an additional year allows for more experience, more independent experience that not all nurse practitioners have had, although many have. And at least the 1 year would be under a different train of thought from the mentor or whoever is going to be attesting or working with them or in the facility. So I'm looking at it as a different type of training, not what we've had before, and that's why it was put in. So that's where I'm coming from. So, period.
Thank you, Dr. Espinoza. You've made a motion. I wanted to give an opportunity to now call for a second from the committee. And then the time is now 4:31. So I'm going to call for a second at this point. Is there anyone to second the motion on the floor from Dr. Espinoza?
Process, so people know that if a second is not made, that is okay. And this would go forward as information only. We would still go out to public comment, Samantha.
Thank you. Hearing no second, as E.O. Melby has just stated, it will be placed for public knowledge.
Okay, thank you.
And then Reza, are we able to put a time limit on public comment as our meeting has officially ended per the time that was in there? But we do want to give this some public comment. And so do you suggest maybe 10 minutes or 15 minutes? What are your recommendations? We do have a hard stop with our board staff as they do not work past 5 p.m. And so we will need to wrap up real soon.
I think ultimately what I would hope to come out of this meeting is, if there are no changes or real concrete changes, as I said, to the draft regulatory text that was posted, that we get a motion to approve that version of the text and send it forward to the board. And then Lori can relay any comments that you had and any additional feedback we get from the public. But that's what I hope to come out of this meeting, so that the board has a recommendation from this committee regarding the text that they're going to be considering tomorrow. I think we should try to give as much time as we can to get any public comments. So my suggestion would be, if we can get that motion, if this committee feels comfortable enough with the text that they've considered, that somebody make a motion and then we go to public comment for as long as we can, and then go from there.
Move to accept the draft regulations with the stipulation that our comments and concerns be forwarded to the BRN.
May I get a second, please?
Second.
Please state your name.
Correct. NP Sally?
Thank you.
That was Dr. Ray who made the motion.
Okay.
Okay, and before we go to vote, I will open the floor for the moderator for public comment, please.
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Katrina Reyes would like to make a comment. 1 second, please. Go ahead, Katrina Reyes.
Hi, can you hear me?
Go ahead.
Hi, good afternoon. Katrina Reyes with the California Academy of Family Physicians. We urge the committee not to take action on these draft regulations today. It appears that the committee has raised a number of concerns with the draft regulations, and the full committee has not had the opportunity to amend the regulations prior to it being voted on by the board. I will reiterate the comments we made at the interested parties meeting. As I said at that meeting, the BRN has been given rulemaking authority in AB 890 to implement many of its provisions. Regulations are promulgated to implement, interpret, or make specific the law. Fortunately, these draft regulations do neither of these. In fact, the draft regulations simply attempt to restate the statute, but does so in a way that is inconsistent with the new law. For instance, the draft regulations define transition to practice as 4,600 hours or 3 full-time equivalent years of clinical practice experience. This definition omits the term additional prior to clinical practice experience, which is how it is defined in the statute. Only using clinical practice experience rather than additional clinical practice experience changes the meaning of the statute, in that it implies that existing clinical experience rather than additional clinical experience is sufficient. While the statute permits the BRN to include prior clinical experience in the transition to practice standards, considering such prior experience is not authority to completely exempt an NP from the transition to practice requirements, but rather to determine the type of transition to practice they should complete. Moreover, the draft regulations don't fully establish requirements for previous experience, as for instance, it does not make a distinction for NPs with a few years of experience and NPs with 20 years of experience. The regulations go beyond the statute, and when determining whether a rulemaking agency has exercised its authority within the bounds established by statute, courts apply a standard in which regulations that alter or amend a statute or enlarge or impair its scope are void. Another example of where the draft regulations are inconsistent with the statutes is in the requirement that a Section 104 NP practices an NP in good standing for at least 3 full-time equivalent years or 4,600 hours. The statute states 3 years, not full-time equivalent years. Full-time equivalent years is significantly less than 3 years, which means the regulations are again altering or amending the statute, rendering it void. There are also areas in the new law that necessitate the board to adopt regulations in order to implement, interpret, and make specific certain provisions. The new law provides that NPs must refer to a physician in certain conditions. However, there's no detail in the law on how this will be enforced. As such, the regulations need to have provisions to ensure referral and consultation agreements are in place and being followed. Thank you.
Thank you, Ms. Reyes.
This is Reza. I'm not gonna take every piece of that. I just want to chime in really quickly. I don't know that this will necessarily satisfy Ms. Reyes, but you brought up the issue of the regulation not using the word additional several times. I just want to show you that we've listened, we've heard that, and in section 1482.3 subdivision A3A, it doesn't use the word additional, but the new text under capital A Roman numeral 3 specifies that the hours towards transition to practice must be completed after certification by the BRN as a nurse practitioner. To me, that captures the meaning of additional, and it rules out any other clinical experience, say, that one would have obtained in school or prior to certification as an NP. So again, I'm not really able to take on each piece of that, but that's a comment that's been kind of reiterated a number of times. So I wanted to just show that we took it into account, did our best to address it. Maybe you still have concerns, but there it is. So.
Dr. Stephanie Dittmer would like to make a comment. 1 second, please. Go ahead, Dr. Dittmer.
Thank you very much. I would like to express my thank you for the changes that were made to the draft regulations since last time they were posted. I do want to make additional comments regarding the lack of the specification of the online education component for the CMA's comment that they had provided. There's no regulation requirement or discussion regarding complete online education and how that fits into the regulations, as well as the discussion that occurred today was healthy regarding the corporate bar of medicine. It is not necessarily just about corporate practice. It is about what is the definition of providing medical care to patients and who defines medical care. It's not just about nurse practitioners being taken advantage of. It is about the actual definition of what that means. And in the current legislative passing of AB 890 and our implementation of regulations, it is not clear and it is inconsistent with the practice of medicine and the practicing of outside standards of procedures in terms of what legal entities we are going to run into in the future. There's also inconsistencies with the referrals and lack of consult. It is not about Stark law. It is about making sure that when patients need care and the person taking care of them is not aware of what they don't know or they need help, that they get the ability to get help in a timely manner. It's not about just prefix arrangements. It's about how do we take care of patients to make sure that they're getting the care that they need. That's what the referrals and consults and the intention of the statute really is about and has not been addressed in the current regulations, nor has the specifications of what mentorships or attestation really means. Without those being clinically clear during the current work and the proposed draft regulations, I still believe that patients are going to be falsely under the impression that they are getting the equivalent level of medical care, and that is a problem without having these issues addressed. Thank you.
Thank you, Dr. Dittmer. Joseph Kachula would like to make a comment. 1 second, please. Go ahead, Joseph. Yes, sir.
This is Joseph Catuolo with the California Medical Association. What has been presented to the NPAC today can only be construed as a working document, not a final draft ready for the BRN's consideration tomorrow, given all the issues of first impression raised at this meeting. In their current form, the draft regs do not provide the level of comprehensive guidance the legislature intended the BRN to promulgate to ensure that 103s and 104s are delivering safe, high-quality care to patients. There are still provisions in the draft regs that exceed the BRN's legal authority. These include the 5-year transition of practice for the and the language in section 1482.4 that state that a 104 NP candidate must practice as a nurse practitioner in good standing for at least 3 full-time equivalent years or 4,600 hours before being eligible for certification as a 104 NP. Additionally, while promulgating regulations on the parameters of mentorship may be difficult, it is a task passed down by the legislature and must be duly accomplished by the NPAC and the BRN. The draft regs are silent on other key provisions of AB 890. To note, the supplemental examination, 103 NP referrals, 104 NP consultations and referrals, and the limitations on 103 and 104 NP working arrangements imposed by the corporate bar and the operative California worker classification laws, which are different for physicians and NPs. To Dr. Ray's point, the medical board has clarified how the corporate bar applies to physicians. The BRN must now do the same for NPs. The advice and recommendations on the draft regs provided by NPAC members today should be given full consideration, and because they address discrepancies and deficiencies in the draft regs, adopted in subsequent versions of the draft regs prior to the BRN meeting tomorrow if the BRN intends to present the draft regs for consideration and approval at that time. California administrative law, sound public policy, and fidelity to patient safety demand that. Thank you.
Thank you. Scott would like to make a comment. 1 second, please. Go ahead, Scott.
Hi, thank you. After 3 physician comments, I'm happy to provide a nurse comment. Actually a question. As far as the attestation of nurse practitioner hours towards the 103 and 104 certification, must that be one person, or can the hours from several, I guess, attestors be added up? If a nurse practitioner works with one person for a period of months and another for another period of months, hopefully those can be added up. If that's not already provided for, I'd suggest that that the committee consider that situation. And then my question, where can the public suggest terms to replace 103 and 104 NPs? Somebody mentioned that earlier. I'd like to know where we can lodge our suggestions. Thank you.
Thank you, Scott.
Real briefly, Reza here. I believe the intent was that you can submit attestations from more than one attestor. So you don't need to use one single person to attest to all 4,600 hours. I wonder if Lori can respond to the second question.
Yeah, they could send those to me. My email is located on our website, but it is loretta.melby@dca.ca.gov. And you could also find it on our website under executive leadership. And our website is rn.ca.gov.
Margaret Parsons would like to make a comment. Go ahead, Margaret.
I do sincerely appreciate the progress on the document since the October presentation, but I believe it is, as described by others, a working document with still great discussion today and thoughtful areas that need to be worked on, amended before it goes to the full board, clarifying the transition to practice and what that mentorship can look like. The intent in the language as written really does seem to include additional training in mentorship and helping the nurse practitioners managing that full panel of patients while they prepare to be independent of supervision. The OPS, the exam, which is clearly outlined in statute, is not addressed. Also, I think we really need to work through that corporate bar language. Is very clear on the medical board side. It needs the work. We need this work done before the regulations are promulgated. Additionally, I think the referral and consultation, lots of interesting discussion today with Stark versus referral versus insurance. To me, the intent of the law fits in with when say we're in an outpatient surgery center where we're doing a procedure, and if we do not have hospital privileges for that procedure, we have to have a letter of agreement with a physician that would assume the care in the hospital. So that's somewhat with the consult language to me when it refers to a nurse practitioner reaching a limit on their ability to continue to care for a certain patient in their complexity of illness. So that reminds me very much of that type of consultative or referral relationship. Certainly with variety of insurance, we will all have different people we work for, different docs for different diagnoses, different procedures, different preferences for certain diagnoses. But to me, it's the safety net consultative of referral language is what's intended in the statute, and I'd like to see it reflected in that way. It's hard when all of our different agencies and bodies use different language with a specific statute or regulatory meaning, but yet there's an intent that might mean something else. I would look forward to further discussion, thoughtful time for the NPAC and its subcommittees to take the comments, draft some new amendments.
Thank you, Ms. Parsons. Join Le would like to make a comment. 1 second, please. Go ahead, Join Le.
Hello, can you hear me?
Gotcha. Yes, we can hear you.
Yes, just wanted to comment that there is a slippery slope of grandfathering into independent practice based on years of experience. Physicians, including international graduates, even those with a full career, must pass USMLE steps 1, 2, and 3 to get a license and must complete a residency program for a particular specialty to get board certified. Therefore, standardizing transition to care ensures all practitioners meet a minimum standard and also minimizes the guesswork and variation in competency. Thank you.
Thank you. Dr. Cynthia Yovanov would like to make a comment. 1 second, please. Go ahead, Dr. Yovanov.
Hi, in regards to the current draft, I just wanted to point out two major concerns. The first is section 1482.3, section A3B. It's the restriction that the attestation must specialize in the same specialty area or category as listed in section 1481A is too restrictive. Especially for those FNPs that may be currently working as PNPs who work within that pediatric population in the same clinic. They would not have the ability to sign off on an attestation because they do not belong to the same population foci. This also applies to those that are double boarded certified. The second restriction is that the person attesting to the transition to practice must not have a familiar or financial relationship with the applicant. This is actually a conflict with the intent of AB 890 for the 103 NPs because the 103 NPs must work in the same setting or organization in which one or more physicians practice. So any provider who's attesting to the 103 NP will have financial relationships with the applicant in the form of an employment or being a partner in a corporation. I would like to recommend that this be striked to the new amendments. Thank you.
Thank you, Dr. Yovanov. Glee H or Glay would like to make a comment. 1 second, please. Go ahead, GLEH.
Hendricks of California Nurse Practice Association. Cynthia Jovanov just made that contribution.
Thank you, Glenn. Committee Chair Gamble Spar, there are no other public requests for comment. Would you like me to close this window?
Thank you, moderator. Yes, please close the comment section. So we did have a motion and a second. I would now like to call for any additional conversation with understanding that it's 4:51. So are there anybody else that wants to have any additional brief discussion before I call for the vote?
Question.
Yes.
If we adopt draft regulations, I mean, the understanding is that, this committee is not going to dissolve as soon as, the statute is fully implemented. And we will reserve the capacity to make additional recommendations to the board for any changes to regulatory language. Is that a correct interpretation of our role?
That is a
Absolutely.
correct
This committee.
interpretation. Yes. Sorry, Reza, go for it.
That's okay. Yes, this committee is not going anywhere. It's in statute. It's still going to be mandated to advise the board on all matters relating to NPs, including further regulations here.
I'm just putting that out there because I know there's going to be members of the public who are saying, well, how can you adopt these regulations where there's some unanswered questions? I think, at least in my opinion, I think we've done a pretty good job in addressing most of the concerns that have been raised to me. And I think any ambiguity will have the opportunity to be addressed at some point as specific cases arise.
Yeah, and I agree, Dr. Ray. I do believe that having the public comments, for us to work as a committee, but then also to hear the public comments is a very important aspect because, hearing from the public and then, even the implementation of writing the regulations as they are and the changes that happen to the draft, that all is a result of not just the committee, but also the input from the public, which we hold to a very high standard. Dr. Espinoza, did you have anything else that you wanted to briefly mention?
Yeah, I just wanted to ask, so I'm understanding as there's changes, we will be able to see these before they go to the board?
So I'll talk about process again really quick, and then we do have to wrap it up. My staff have a hard stop at 5 o'clock, so we will not be able to take the next agenda item. We will have to adjourn immediately after this vote. The regulatory process, if passed tomorrow to enter in, does not come back to the Nurse Practitioner Advisory Committee. You guys will be done with this particular phase. The regulatory language would be passed by the board. It would go to board staff. They would write an executive summary, initial statement of reasons, a final statement of reasons, and it would go forward to DCA, from DCA to agency, from agency to the Office of Administrative Law. At that point, it does go out for a 45-day comment period. If after that 45-day comment period, there are suggestions that that we are able to address, then at that point, yes, it would come back to the Nurse Practitioner Advisory Committee. But that is not a guarantee that there are suggestions that we would be able to address during that point. So I can't say, yes, you will get this again. This may be the last time that you get this particular set of regulations, as it may completely fly through. I know I'm talking with rose-colored glasses right now, but it may completely fly through and it may be accepted and go to OAL and be finished. That doesn't take away an ability to further amend regulation. And so again, like what Dr. Ray pointed out and sought clarification on, is that at any point we can always do another regulatory package. And just for the committee and the stakeholders to be completely aware of, Woods has a bill out, AB 5852. Again, that's AB 852, and that is a cleanup bill that they have in response to AB 890. So if there is anything law that you guys want addressed, want adjusted, then you would contact Woods to have that put into that cleanup bill. So just so that you guys know that there are plenty of ways that this continues, that this is not the end. So thank you guys very much.
Thank you, EO Melvin. The time I'm going to call for the vote. I will start with Dr. Ray.
Yes.
NP Pham. NP Griffin.
Yes.
Dr. Espinoza.
No.
Dr. Kevin Maxwell, NP.
Yes.
Public member Betha Schnell.
She had to drop off at 4:30. She will not be voting.
Okay, thank you. And my vote is for the affirmative. And so with that, we have more votes for the affirmative. And so we have voted for this information to move on to the BRN tomorrow for their meeting.
Thank you. Board staff will be reaching out to you guys to schedule the next meeting, but we will then have the calendar for voting at that point. But we will schedule the next meeting with you guys to get a quorum and move forward with that. So we will skip agenda item 7.0 and we will go straight to agenda item 8.0, Samantha.
Okay. Agenda 8.0 is adjournment. I wanted to thank everyone on the Impact Committee and thank everyone for their public comments. I hope, and everybody here hopes, that you have a happy and safe holiday season. Thank you. Meeting is adjourned at 4:57.
Thank you guys. Have a great evening.